Just wish for the segregation of that
Huh? Also, oh yes, yes.
Please, Lordship, I beg to mention item number 19, Lordship. For the petitioner, I have informed my friends also.
Yeah.
I have informed to respective respondents also.
2020 matter.
Yes, Lordship. I just need to get some instruction, Lordship.
Mr. D.
Mr. D, I have
no objection, my lord, since he has requested it.
2 weeks.
Let come after 3 weeks, my lord, since he need to complete the instruction also.
3 weeks to allow the petitioner to complete the instructions. Yes.
much blessed, Lordship.
Yes.
May we please, your lordship? Your lordship, I beg to make a mention of item number 14 and 15. Your lordship, I beg 2 weeks time, your lordship.
Why? Where's Mr. Mahanta?
Your lordship, his health is quite down, so.
Okay. You're for?
For the petitioner, Your Lordship.
Your name?
Peeling Door, Lordship.
14, 15 request from Mr. Emlingdo
Yes, your lordship.
for the respondents due to the as this argument council interposed list after
After 2 weeks, your lordship.
weeks.
Highly obliged, your lordship.
Yes.
May I please, Your Honor? I would like to mention item number 21.
Yes. 21.
21.
Mention for an urgent matter to be taken after orders. One CRP, my lord. One CRP I have already filed. I beg to mention.
One
that it
second,
will be taken after orders.
Mr. Vicky is still mentioning. Yes.
I would like to mention item number 21. Mr. P. Obin is still out of station. So kindly 2 weeks time will be given.
Yes, as the counsel for the petitioner is RC. Yes, Mr. Siddiqui. What do you want?
Obliged, Your Honor.
Mr. Siddiqui, what do you want?
Yes, I beg to mention one item for an urgent matter. It has already been filed. If it could be taken after the orders, my lord.
What matters only
Yes,
filed unlisted? No.
It has already been filed. Now I am taking it for unlisted, my lord.
What's urgency?
Urgency is that, my lord, an order and permission was granted by the Deputy Commissioner for holding the annual festival in Mandargan Shrine. But it was stayed, this order was stayed by SSP and DC, that also without notice to him and without following.
When is the festival scheduled to be held?
My lord?
When is the festival scheduled to be held? When is it scheduled?
It is already, it is scheduled to be held on the next Sunday, next Sunday, my lord.
This coming
Last
Sunday.
Sunday also there, but yes.
Let it come tomorrow. Let government take instructions. Yes?
Government is not a party, my lord, here. It is between two parties, civil matter. Government has not been made a party. That is my grievance, my lord. Actually, the DC should have been made a party. State should have been heard. But behind
Okay, then.
the back, it has been done.
No, let it come.
No.
You've been filed, let it come here.
Okay.
Please, Your Lordship, I beg item number 20, Your Lordship.
For what? For adjournment?
Yes, Your Lordship.
Nobody on the other side.
No objection, Your Lordship. But we are ready actually in this matter.
Your Lordship, actually, in the affidavit, they said that they are ready to pay, Your Lordship. But since the matter is between the two Nagmas claiming to who is the Nagma, Your Lordship, which is now.
Yes?
I thought he was mentioning item 24, Your Lordship. Hafizur Rahman.
Who's appearing 20? You are appearing 20 also. What's the matter about?
It's compensation, Your Lordship.
There's no point in this matter pending. 1 week, yes.
Right, Your Lordship.
Obliged, Lordship. Your Lordship, I beg to mention item 18, Your Lordship. In this matter, on the last occasion, we had to file an additional affidavit.
For?
Because as there were some defects in the writ petition, Your Lordship. So I'm praying 1 week's time.
Additional affidavits as there were some defects in the writ petition.
Your Lordship, if you
Meaning?
recall, Your Lordship, if you recall the last order, Your Lordship,
Cannot recall anything. You have to say this.
there was some type of graphical error, Your Lordship, in the writ petition. Hence, we were asked
Why
to...
additional affidavit is there defects in the petition? That's
Your
what.
Lordship, there was this notification dated 13/09/2021 was not annexed in the writ
Okay.
petition.
Right then.
It's
1 week's time.
not typographical error. It was hard on merit and some defects were found. So
After 1 week, yes. 1 week to correct the defects, yes.
Much obliged.
Yes, MS Esrum Thao submits that as due to inadvertence, the defects can be corrected. She prays that she will have 1 week further time. Prayers allowed.
May I please, Your Lordship, I beg to mention item number 17. The Conducting Council is having some personal difficulties.
Who, Mr. Chakravarti?
Yes, Your Lordship. So I pray for 2 weeks.
Yes, MS Kolni. You have some instructions on these. You want to finish it off?
My lord, let's appear because otherwise senior counsel may later on say that he was not present.
When? 3 weeks?
2 weeks time.
2 weeks, yes.
Yeah, obliged.
Follow this.
Item number 1.
please, Your Lordship. Here, what has happened, my lord? The respondent number 5, who is a private respondent, my lord, was appointed without following the due process of law, my lord, and which against a post which is reserved, my lord.
Meaning?
It was a reserved post, my lord.
Okay.
So he was appointed against
Without
that post.
selection.
No, my lord. Kindly come to annexure number 1, my lord. This was a communication to the respondent number 4, my lord.
Yes.
With reference to the subject.
The post of beyond language is reserved for Garo community.
Lordship.
Your request and only one Garo only can. Okay, fine. What happened after that?
After that, the respondent number 4, my lord,
Yeah.
forwarded the names of 13 Garo candidates, my lord.
Then what happened after that?
Thereafter that, they were expecting that they will be called for selection process, my lord. But instead, my lord, they were shocked and surprised to find that on 24th April 2023, my lord, an order has been issued by the
Where's that
director.
order?
It's at annexure 3, my lord, page 21.
Page?
21, my lord.
Now, how is that possible? Know what this order says? So they did do the selection.
Lordship.
They didn't have the selection
No,
at all.
no,
So
not
what
at
they
all,
did
no.
was
They appointed.
who is the employee? She's already working
She
there.
was already working as a cleaner, my lord.
Who's appearing for Muda? You're appearing for Urban Development Authority?
The government of Meghalaya.
You are newly impaneled?
Yes.
Okay. Then you have to issue notice to the Urban Development Authority.
Lordship.
Lordship,
Already appointed. 20?
No, I know, but the order has been issued, my lord.
And whatever the post is subject to the outcomes. of the
Lordship will have to seek instructions whether the appointment was made against the post to which she has
Exactly,
applied.
yes.
And also, my lord, in this instant writ, they are people who have just been recommended. Their names have just been selected by the employment.
No, see, we don't need to go to that emotion state. The thing is that it's only grievance that the post reserved for Garo category and a Khasi has been given. Now, whether that can be done because they're already working as cleaner, whether it's by due selection or was it against this post or not. I heard Mr. A.G. Moment issue notice. MSS Sham is present except those on behalf of respondents number. That means only respondent number 1, 3, and 4.
5 is the private respondent.
Yeah, 1, 3, and 4. 1, 3, and 4 because number 2 they are going to issue notice to respondent number 2 and 5 within 3 days. This is a matter after 2 weeks.
And there's a misapplication also, my lord.
Misapplication which will be considered in the next date.
What?
Item number 2.
Yes.
Lordship, the matter is he's a retired school teacher of St. Denis and he's
Have you corrected the registration properly? Have you checked it, Mr. Shulai? It's in correct form now.
Lordship, this is your Lordship. Lordship, I'm very to say that the Lordship, the drafting is not in order, your Lordship. You going by the version, your Lordship. It's very difficult.
What is your prayer?
Lordship, kindly come to page 7. Lordship will kindly come to page 8. Gratuity, Lordship, delayed payment of gratuity from which period?
Okay, let us say, what is your case?
he's a retired school teacher and
Yes.
he's fighting for the gratuity because only 350,000 has been paid to him.
What is he entitled for? What is he due to get?
For the balance amount,
What's the balance amount?
16.
Where's the sanction for the entire DCRG amount? You see, you have to claiming must be on some cogent basis. Now you're saying that you've been paid how much?
350,000.
How much not paid yet?
16,50,000.
So show me show me how you're entitled to that 16,50,000. How do you come at that amount? Where is that? To show the court that this is the amount that was fixed, is sanctioned, and instead of that,
Page
where?
13, sir, annexure 2.
Lecture?
Annexure 2, page 13.
Page?
13.
Yes, don't be, you speak up, yes. Lecture 2, page 30 only says that you received 350,000. Where's the other amount you're claiming? See, if you claim something, you have to have some basis on why you're claiming this amount. What is the basis? I couldn't see anything where this amount at somewhere that you see this court trying to help you. You see, you have to prepare the case properly. Now you're saying the petitioner claimed gratuity as statutory right is 3 lakh only was made to authority representations for a balance of 16,50,000. How do we come to this figure 16,50,000? You have to, if you want some relief from the court, you have to show that this is the amount that was payable to you. Yes, Mr. Shulai, you kindly help the petitioner because I don't think she's in a position to satisfy the
The
court.
only thing is, Lordship will have to notice will have to go to respondent number 5 Lordship, and then some correction also is required in Lordship. Kindly come to page 3. Respondent number 2 and 3, Your Lordship. These respondents are required to be corrected, Your Lordship. These are improper.
3 and 4, 2 and 3.
Lordship, kindly come to page 3.
Overlook that.
Respondent number 2 and 3, Education Secretary. See, it's not in a proper form, Your Lordship. Commissioner Education, Your Lordship. It should have been Secretary to the Government of Meghalaya Education Department, something.
It's also, he's not aware of how to nomenclature.
Anyhow, Lordship, let notice.
Yes, what's your name?
Eureka.
Full name?
Eureka Wadri.
Head MSE Warjari. The accounts of the petitioner, issue notice. Mr. Andy Shula is present on behalf of respondents
124, Your Lordship.
and accepts note together as it now accepts notice. The nomenclature given for the parties doesn't seem to be proper. However, in interest of justice, the same is overlooked as considered by the AAG. Stop. Issue notice respondent number 5
Lordship.
within 3 days.
Apply, Your Lordship.
This after 3 weeks.
Item number 3.
May we please, Your Lordship? Your Lordship, if I may, in this case, Your Lordship, the petitioners are highly aggrieved with the enhancement of the rent, Your Lordship, which varies from 65% up to 216%, Your Lordship.
From how much?
From 65% up to 216% of enhancement.
From what?
65%, Your Lordship.
65%? 265%?
No, 216. Up to 216, Your Lordship, the enhancement rate. So, the Secretary of Muda, Your Lordship.
Where's that? Yes, so carry on, sorry. Yes.
Your Lordship, the Secretary of Muda White, a notification dated 12 April 2023, Your Lordship, issued a notification for the enhancement at page 25, Your Lordship. I'm referring to annexure number 3, page 25. Issued a notification for the enhancement of rent, Your Lordship. Your Lordship, being highly aggrieved by this.
Just read it. This notification dated
it is
12th April.
Dated 12th April.
Read slowly. Read it.
It is hereby notified that the monthly rent for shops at Meghalaya Urban Development Authority shopping complex cum parking lot at Police Bazaar will be enhanced as indicated below. The new rates will be effective from April 2023 for all municipal stalls, newly allotted stalls and bid portions. Point number 1, all municipal stalls, rupees 68 per square feet. Point number 2,
It's the enhanced rate.
Yes, this is the enhanced rate, Your Lordship. Point number 2, newly allotted stalls, rupees 49 per square feet. Point number 3, bank premises, rupees 45 per square feet. Point number 4, bids portion, rupees 33 per square feet. All stall allottees are directed to execute fresh agreement with Meghalaya Urban Development Authority by April 2023 and are requested to deposit the balance security deposit equivalent to 6 months rent as per the enhanced rate above.
Okay then.
Your Lordship, the members of the Petitioners Association.
Is by association or a single person?
No, by a single person, Your Lordship. He's the secretary of the association. From time to time, have been complying with all the instructions and directions issued by the MUDA, and also have been cooperating with the payment of enhancement of rent as per the agreement, Your Lordship. So, Your Lordship, I would like to take you to page number 4, Your Lordship, at para 5. Your Lordship, if I may read para number 5.
Yes.
That the petitioner states.
But what kind of petition is this? That their association. You come association, comes a petitioner.
No, actually,
if you come alone, you come by your own stall.
No, Your Lordship. This is by the Petitioners Association.
Where is it? Where's your? Where do you say that you're presenting the association? So where's the association's name?
The association's name is Urban Shopping Complex Association.
No, the petitioner.
He is the secretary, Your Lordship.
Where's the registration?
Registration is at page number 10, Your Lordship. As
no, but then why is the association not before the court?
Yes, Lordship.
Why is the association not before? Why is the association not before the court? Why is this? He doesn't even show as a secretary in the petitioner. He says Kinmaulang Lingdo, son of Arki Datta. That's it.
But in our at para number 1, we've stated, Your Lordship, that he's the secretary of the Urban Complex
This
Association.
petition is totally
That
rejecting, my lord.
Yes, Your Lordship.
It's incompetent. You would go and file it in a proper form.
Your Lordship, since the last date, it's tomorrow, Your Lordship, for debts.
We can't do anything. In this kind of petition, we can only give relief to your one single petitioner, not to the other shops.
My lord, that
If
also
any
cannot
case
be
is
given,
made
my lord. That also cannot be given.
I said at the most.
My lord, if kindly see, my lord. See, kindly see, my lord. He says he is a tenant. Kindly see the agreement which he has appended, my lord. The tenancy agreement, my lord.
Where?
Tenancy agreement, my lord, page 16.
1/6.
Yes, 1/6, my lord. My lord, see the name of the tenant, my lord. It will appear in page 24. Kindly come down, my lord. Page 24, my lord. Down this, my lord. Bayadalin, my lord. Bayadalin Kharsintiu. Now, my lord, if it is to be assumed, my lord, this is individual case. Kindly see the name of the petitioner, my lord. Is Kinmaulang Lindo, my lord. Now, petitioner can base a case.
Not necessarily.
This has to be rejected.
Writ petition examination appears to be incomplete and incompetent, not in proper form. He must dismiss with liberty to the petitioner file afresh. You have to advise.
Highly advised, Your Lordship.
Item number 4.
May I please, Your Lordship? Your Lordship, let the matter be taken up tomorrow.
Only for condemnation. Why tomorrow?
The connecting council is out of station.
For notice only.
May it please Your Lordship?
Yes. File objection.
On behalf of the respondents, you just filed the vakalat number today itself.
No, we filed objection. You have to objection to the condemnation.
No, we have not even received a copy of that, Your Lordship.
Self copy. Why? How can you appear without even the matter being taken up for the court? It's an application under Section 5 of Division Act.
I have not received any copy.
It doesn't matter. This is an application. Heard MS Ailalu.
Yes, Your Lordship.
Yeah, this is an application for condition of delay of 20 days in preferring the connected solution petition against impugn order passed in against Thomas. This is an application heard MSS Lalu for the petitioner stroke applicant. Next line. This is an application for condonation of delay of 270 days in preferring the connected civil revision petition. Stop. For both the respondents.
Yes, Your Lordship.
Mr. S. Walang, another counsel who is the president in court, has accepted notice on behalf of both the respondents. No further notice called for. Next part, he prays for how much time to file objection?
After 2 weeks, Your Lordship.
He prays for 2 weeks time for objection to the condition application. Yes, up to 2 weeks. You should not take time in these things. Why you take time?
We are not aware, Your Lordship, of the order
What are order?
passed by the District Council Court, Your Lordship.
In 2 weeks time, you're preferring this is a condemnation application, correct?
Yes.
You should have that in you. Why should you say that wait for my senior to move it? It's a misapplication. No negative or positive orders are coming. It's just visions of notice.
5.
Have confidence.
Obliged, Your Lordship.
That's the thing. Yes, Mr. Jha.
My Lord, this is a contempt with regards to that nursing.
Which one?
Nursing allowances, non-grant of nursing allowances, my Lord.
You granted now?
Respondent.
Filed an affidavit.
You have granted it. For that period from?
No, my Lord. They have filed an affidavit, my Lord. Respondent number 2, contemptant number 2 has filed. My Lord, in page 2.
Of the affidavit?
Of the affidavit, my Lord.
Where is that? Lieutenant General Pradeep Chandra Nair.
Yes, my Lord.
Yes.
At last. Para 1, my Lord. Received a copy of writ petition. My Lord. That's all. Copy paste, my Lord.
Your Lordship, I'm praying if this matter can be taken up at the end of the board, Your Lordship.
No, why you receive copy writ petition? It's a contempt application. So double contempt.
My Lord.
No, one thing, have you been paid your nursing allowance?
Not.
Discontinued 2019, correct?
My lord. 2019.
For that period, you already remustered as nursing assistant.
Already, my lord. I was
Remustered from
I
when?
was enrolled as a nursing assistant, my lord.
From
The
which
petitioners were since his recruitment was as a nursing assistant.
No, when were you recruited?
My lord. That fact would remain.
You should know when you recruited.
Lord,
Were you recruited before the scheme came into
before the scheme, my lord.
when the scheme was still in operation?
Yes, my lord. And the case was the writ petition which we have filed, my lord. That was for the same work, equal pay for equal work, my lord.
Not a question equal work. See, the thing is that if I understand correctly, this nursing allowance is that it was a scheme that was introduced for payment of nursing allowance. Those people discharging these duties over her rifleman nursing whatever. Correct? He's rifleman
Yes,
nursing
yes,
assistant.
Nursing
Okay.
assistant.
Okay, fine. But then when they found out after 2019, before 2019, that he did not possess any certification from from institute or from the nursing association, whatever, this allowance is discontinued. So at the most he'll be entitled to only that portion of allowance when it was in operation, the scheme, that's all. So if you serve maybe from 2008 to 2019, only that period he'll be entitled.
As far as that he was given, my lord. The stand taken by the.
No, but was he given at any point of time?
Yes, my lord.
What he claiming now? Again, he claimed for parity.
Not parity. That the order which was passed by that was violated, my lord. I should be entitled.
And let come and report. Let's hear that from Monica.
Item number 6.
I've sent the affidavit for vetting to Bagmara.
Story has become very sad now. This Bagmara Municipal Corporation.
Yes.
Become very sad story with the day.
Why, man?
Why? Because every time we're waiting for instructions now for.
No. Last time I have said that we need to file an additional affidavit. I'm just praying for 10 days time, my lord. We'll receive the affidavit back, my lord, and then we'll file it. My friend will have no objection.
Actually,
you're putting submissions into his mouth.
No. I have no objection, my lord. Actually, it's.
And you put submissions to his mouth also, so that you're going to pay the amount by tomorrow.
The grievances actually, Lordship, actually I need the salary actually.
It's not that, it just says that whether as per the RTI, that's already fully utilized.
Fully utilized.
Now that it is shown that budget provision for that's already been given and you will finally fully utilize.
We just need to file a 2-page affidavit.
Mr. SD has submitted that the Prince has allowed 1 week further time, 10 days further time to file affidavit.
7.
My lord, here the issue was one of implementing a policy of transfer, if Lordship remembers. On the last occasion, transferring the CAPFs, my lord, where we wanted a common policy for all the doctors. Now, my lord, on the last occasion, a submission was made that a division bench had given them 2 months' time to comply with the orders.
Right.
That expired on April 30th, my lord, and therefore the matter was fixed today. My lord, Lordship had observed that that they would file an affidavit after the at least expiry. Otherwise, they come to not file.
Where's Dr. Muzika?
Your Lordship is on legs before.
We'll take after some time.
Your Lordship at the end of the board.
End of the board will soon be onward, yes, after some time.
Pleasure.
8.
You know what they say about CAPF? I've heard there's among the forces they say court administered police force. Because everything they have to come to court.
For everything.
It's like that.
Lordship, I filed an affidavit and I'll rely affidavit filed by respondent number 1.
3. Number 3.
Respondent number 3, yes.
And he will.
Private respondent number 3?
No. Eastern respondent, Lordship. And he will rely the affidavit for the other respondent.
There is see. There are number, how many respondents are there?
Respondent number
5.
3 is fisheries.
5.
So 3 will depend, number 1, 2 and 4 will depend on 3. All of them?
All of them, yes, Lordship.
Then Mr. H. Abraham submits that the affidavit filed on behalf of respondent number 3 will suffice. for all the other respondents. You want to file a rejoinder?
No, finally having.
Such Mr. Like for Mr. S.A. Sheikh, the third wish to file a rejoinder. Any urgency?
No urgency, Your Lordship.
This is matter for hearing. On so and so. How's your health?
I'm fine, yes, absolutely not, Your Lordship.
9.
May I please, Your Lordship? Affidavit is ready. I have supplied the copy also. Due to some mistakes, could not file on Friday, my lord. I'll file during the course of the day, my lord.
Mr. S.K. Hassan, for respondent number 5, submits that affidavit file causally.
Government affidavit is clear, Lordship, because this is temporary committee, my lord, because government has considered that because the parents and guardian was
We're not arguing the matter right now, Mr. Sheikh.
Then, Lordship, can you, this week only, Lordship.
It's urgent.
Yes, Lordship.
Mr. S.K. Hassan submits that the affidavit on
Any
behalf
day
of this respondent number 5 will be filed in the course of the day. Stop. Mr. S.A. Sheikh submits that the matter has some urgency and prays that it be listed for orders, for the orders. But this is matter of the 3 days for the orders.
Highly obliged.
Yes, no?
Obliged.
10.
Your Lordship, agenda is ready, Your Lordship. I will file during the course of the day, Your Lordship.
Yes. Your name?
Yudhar.
You, Mr. D. Nyota, General Counsel for the petitioner, submit the joinders. It will be filed in the course of the day. So accordingly, this is a matter of 2 weeks. So and so appears for so and so. Like the court can name this.
Obliged.
11.
Lordship, in this case, I'm yet to receive instructions, so I may be given another 2 weeks' time, Your Lordship.
What's the matter about?
It's a land acquisition.
What the one you're asking for?
See, Lordship, it's like this. Since 2017, the respondents have come to the land of the petitioner, and then they have made some arrangement to take the land to acquire for a fire station. But up till now, nothing has been done, Lordship. So that is the thing.
It's a counsel of the party, why?
No, just because some letters are mentioned, this counsel are mentioned in some letters. Otherwise, it's not necessary.
No affidavit from you. Yes, Mr. H. Ibrahim.
1 to 6, Your Lordship.
Okay, 1 to 6 praise funds allowed. Further, how much time?
Given 3 weeks' time because I'm yet to use.
2 weeks' time to obtain instructions to file affidavit. This accordingly on so and so.
Highlight the Lordship.
Clip on it.
May I please, Lordship, Lordship, the affidavit is ready. Was just waiting for the DAG's signature. I pray for 1 week time, Your Lordship. DAG's signature.
Whose signature?
The Deputy Accountant General's signature.
May I please, Your Lordship, I have received the Paradise comments, but I need some time.
MSS Bharatchaji for 1 to 3 and EB Prasad for respondent number 4. Pray for allowed 2 weeks for the time to file affidavit. Yes, thereafter and so and so.
Hearing 13.
I've been reading the 2022 judgment. I've noticed that it's a judgment in personam. It is not only limited issue is that if the counterclaim is filed.
Let us, yes. 22, this 22 SC online. Udi Lalit. Excuse me. Yes.
You'll have to read the entire judgment to understand
the judgment just Dhulia.
Pardon?
Judgment just Dhulia.
Yes, Your Lordship.
Yes.
Feeling slightly giddy, Your Lordship.
Why?
Just now.
Not feeling well?
No, just now I just felt giddy.
You're able to continue with the hearing?
I think we'll take another day, Your Lordship. Just,
Lordship,
maybe short date.
Citation the referred by, I think it's the same one which I...
Same one, para 19.
Exactly. Have to understand that.
But para 19 Mr. Kanta is saying that it is in personam.
In the entire,
But in para 19 is overlooked the earlier judgment. So anyway, when you are this week or
this week.
This is matter on Wednesday, as the senior counsel is suddenly feeling unwell.
16.
Pleasure.
16. 16.
Well, I have received the record, my lord. Record is.
What does it say?
Record, my lord, is the application they have filed, and on the basis of the application they have passed an order, and both the parties was heard, my lord. Yeah, record is there. If you want to examine this, we will examine.
What will the matter about?
This is Nokma matter. my lord.
Just refresh.
In this case, my lord, my case is that there is one Marakapara Aking. Then the person who is Nokma there, she doesn't have one son, and her other sister also have no female issue, except one youngest assistant, and that one also married to another person which are not the same, not the people that, because they should marry according to system of supplying husband, meeting person. So in that case, there was a case in 1935, my lord, before the Deputy Commissioner, my lord. And the Deputy Commissioner in 1935, Mr. Shaw has decided that this case
Finally decided.
And thereafter, my lord, in 1961 they tried to revive it. Then in that case also the EM has rejected it. Then subsequently they filed again. Then it come to the CM, respondent number 2, and then he said that let the matter be taken up to before the EM to take evidence. So against that I come before the High Court, Your Lordship.
Let's just go through the orders, then we'll get
The EM order is page 41, my lord.
page.
41, my lord. Annexure 12.
Now we start from the first order. Mr. Kinjing says that in 1935,
yes,
the Deputy Commissioner Shaw at that point of time has settled the issue, and so subsequently all proceedings become non-est. Is that a correct thing?
Yes.
Let's
From
see.
paragraph 8 onward, my position is very clear.
Okay, let us see paragraph 8
Paragraph 8.
onwards. Yes.
That Marakapara Aking originally belonged to Ranji Machik of Nangminji clan and late Asin Marak of Mrong clan. And upon the demise of the late Ranji Machik and late Asin Marak, their only son Arongsangma borrowed money from other clan by mortgaging the Marakapara Aking, and in due course of time, due to the huge debt which had incurred by the said Arongsangma, there was a time that the position of Marakapara King was on the brink of alienation to other clan, and the matter went to the governor in council. When the matter was adjudicated by the Deputy Commissioner, by following the practice of the Karo custom, with the arrangement being made, Sri Mansang Marak managed to repay back the loan amount which was taken by Arong Sangma from the other clan, and was able to save the Marakapara King manor.
Yes, okay.
Then, while the matter is pending in the Deputy Commissioner Court, a question arose as to who would be the successor of Wanji Machik.
Wanji or Ranji?
Wanji Machik. As both her daughter, Srimati Kasi Machik and Srimati Rensi Machik, were married to the person belonging to the Chambokong clan, which clan did not favor by the Chachis and the Maharis. And whereas, on the other hand, Manseng Marak, who had married to Jiet Machik, was the Nokma of the adjacent Aking, that is Karijora Aking. Therefore, all the churches and the maharis of the Mingri Michik were in favor to keep the Marakapra Aking to Mansing Marak. As such, the then Deputy Commissioner Asia, by order dated 31 July 1935, passed in political case number 12 of 1935, declared and matched the Marakapra Aking with the Karijora Aking, and the order for prohibition of the Masjidar and lineage of the boundary, which accordingly prepared by the office as Karijora Aking number 2, 15 Karijora village, Mansang Nakma, merging the Marakapra Aking and the Karijora Aking. So it was matched. Then this is the, for easy reference, the material fact of the case as reflected with the order dated 31/7/1995 of the Deputy Commissioner is reproduced here in below. And when that is paid up in full, the claim of Sangram Marak became fully satisfied, and he has nothing more to claim. He cannot get the thing, the Aking under those orders, as installments are being paid. This installment due on 4 March and 36 and 4 March 37. So Samara Marak has no ground to object receiving this amount on any plea whatsoever. Now comes the question, who is Aking holder on behalf of the Nangminja clan of Marakapara Aking village? Laskar Khalisan as Ranjimachek died recently. Her husband died some year ago. There was no daughter, nor Nokram. Then Ranjimachek then was below your lordship in that admitted chronological 3 years.
Yes, come to next page.
Ranjimachek, Mengrimachek, Wanjimachek. This Wanjimachek has 2 daughters, and these are Kasi and Rengzi, and these both of them married a Chambokong clan.
Yes.
It is admitted that Mary Machik, that means other sister, who lived in Marakapra, married the so-and-so, then Ranjing, and lastly the Depok, and he also saw death. Consequently, as claimed by the claim, no die was claimed for Kim when Mary Machik married out of Mrong clan into Mangsa and Dangpo clan, that the Mahari and churches agree with her and have no objection. Then come the next important proclamation. She is the own sister of Ramji Machek, now dead, and he is so the next kin for the Aking and Nokma. She has no daughter. Her younger sister, Wanji Machek, had 2 daughters, Kasu and Zangsi, and they have married into the Chambokang clan, not Morong clan, like their mother, Menri Machek. Now wishes to keep one of these daughters as her Nokma, but the churches and Maharis object, as they were not married to Morong clan. They have no objection to Nangminja clan, women marrying out of Morong clan, but property such as Aking should not go with them, because the husband also has a connection with the property matter. But property such as Aking should not go with them in such case as unless they marry Morong clan men. The churches and the Maharis, except for Minkri Machek and Manji Machek and her daughter, all wish to keep Marakapara Aking to Mensi Marak, who has married Jiet Machek. These are from their own clan.
Yes.
Then Jiet is a Nangminja clan, and Menzeng is a Morong clan, and is already Nokma of Karijora village, holding it for the Nangminja clan. Consequently, as Ranji is dead without heir, and Mengri and Wan have married into their own other clan, the Morong clan, which is looked on Nangminja clan, Nangminja women clan, mating clan, for custody of Nangminja clan property by right of marriage. I keep this the king of Marakapara to property by right of marriage. I keep the king of Marakapara to Jiet Michek, who is of Nangminja clan, and who granddaughter of Dongri Michek. This Dongri Michek is also a Nakma of the adjoining the Karijora, younger sister of Jinse Mechik of
It doesn't say here, it just says here, consequently, as Ranji is dead without heir, and Mengri and one have married into other clans, in the Chambogang clans,
Yes.
and other than Morong, which is looked on as Ningminja clan for custody of Ningminja's clan property by right of marriage. I give the Aking of Markhapara to property by right of marriage. I give the Aking Markhapara to Jedi Marak, who is of Ningminja clan and who granddaughter of Dongri Mechik, younger sister of Jinsi Mechik. Now, where it says that who is the Nohma of that Karijora?
If we can just pause, my lord.
Yeah, my lord.
Just a minute. Just a minute. The issue here, my lord, the Nokma has two daughters. And two daughters.
They married outside.
Outside.
They became disentitled.
No, my lord. That is not a settled law. The
Yes.
settled law says otherwise, my lord. When the mother is still alive, it is the mother decision, not the child decision. If the mother is no longer there, my lord, then it is the child and the Mahari will decide. This is a settled law.
Settled law will not apply here because this judgment has been passed in 1935. We're just interpreting this judgment. We're not interpreting the custom, Mr. Day. Yeah, she can take anyone also.
No,
she can take anyone to. That is Garugasam is different.
My lord,
suppose there's no daughter, she can adopt.
My lord, what I'm saying, that is the custom. That is the research book says so, my lord. The custom was, it is the mother who will decide when she is still alive. And if she is no longer there, it is just Chara, my lord. And if the husband has a substitute wife, then it is the husband and the substitute wife will decide.
Now see out here, consequently Ranji is dead without heir. And Mengiri and one have married into other clans. So she is dead, gone.
Yes, my lord.
That gone, that means that it goes to the Charas and Chachi to decide now marries.
Yes.
What will happen to the King?
What I'm
is
saying,
the custom has taken a back seat because of the factual situation in the case.
No, what I'm saying is this, my lord.
Yes.
By getting married to the Chambagon,
does not extinguish the right.
Yes. That is the position.
Maybe.
That is the position,
maybe. But can a question which has been decided in 935 be re-agitated?
No, I'm not saying that. I'm not saying that.
And if by virtue of this order, simply put, if I understand correctly, and simply put, if by this order, you can just say this Karijora Aking has been merged with Marakhapara Aking. Marapara is gone because nobody else, but it belongs to Ningminja clan to maintain that sanctity of Ningminja property. So since they says Karijora Aking is still managed by Ningminja people, so we put the two Akings together. Now can you come after how many years and try to again resurrect this Marakhapara Aking?
What I'm saying,
I'm not saying that it's final, but it's just the understanding. I might be wrong.
Yes, my lord. What I'm saying is this.
Yes.
This is the part where my senior is hesitating, saying that they have no right to claim.
No, he doesn't say. He's just reading the order.
No, he's just reading. Basing on this, he is making the submission, my lord.
Yes.
What is my understanding is this: if the EM pass an order, maybe an application wrongly, rightly, whether they have claim or they doesn't have any claim, my lord, an application was filed. Now, EM has decided in the application. Now, what is the duty of the EM, my lord? To follow Dore Sangma case, my lord. If Dore Sangma case is not followed and an appeal is filed under section 8(2) of the Social Validity Custom Act, my lord, whether it is not the duty of the CEM, my lord, send it back that you record the evidence.
Record. What is the point? Why are you going to engage futile exercise? If there has been no adjudication, we can understand. Suppose you file. Suppose the no dispute you file an 8(2) under the Social Validity Act. Fine, it comes before the EM. Doesn't hear you. He just passes an order. Then finally, the principle Dore Sangma will apply. Where the basic, fundamental principles of judicial procedure have to be followed. That means that both will be given chance to adduce evidence, to produce whatever materials you have, then decision is done. In this case, it's not like that. In this case, there's an order only standing. 935 order by which this Marakhapara Aking is gone.
My lord.
Right. Just listen.
Yes.
Just listen. Now, after 50, 60 years, someone comes and files an application that my right still exists. Now, by coming to this order, do they deserve a hearing?
No.
There are some cases where hearings are deserving.
What I'm submitting is this, my lord. I'm neither for the petitioner, neither for the private respondent.
You're a referee.
Yes, my lord. Here, my lord, an application was filed. It was decided without giving proper hearing. That was the understanding of the CEM. That was hesitated by the private respondent before the CEM.
Correct.
Now, my lord, the order was in favor of the petitioner, my lord. CEM just said, my lord, you record the evidence. The order may be again in favor of the petitioner.
See, why should they be what do you call it? why should we put to that procedure again?
Open for
Or expose
adjudication.
the threat? Now suppose this matter is dead and gone. It goes for adjudication again. This EM in his own mind says, "What? Yes, I find something wrong." After the evidence collected, like you saying, Gari customary law says that that the rights cannot be. Then again, it'll give rise to another monster. Then again, other proceedings. Again, Dore Sangma apply. Again, go to CM. Again, come here. Again, remanded. We have to put an end.
What I have learned from my lord in one of the case where my lord has said me outside the court that Nokma matters are all bouncy matters. I remember that word.
Bouncy matters. Yeah, they bounce around. That's what I'm saying. That's what it is.
So it is for the private respondent to satisfy this order.
Let them see, we are hearing the petition right now, but as the case saying, he's just reading the order 935. And if the order is 935, at least some sanctity be given to it, That it should not be the interference. Is there any scope for interference by any subsequent proceeding of this order? That's the thing.
Well,
if there is, well and good, they're right to. If not, what's the point?
That my friend has to hesitate on that.
Yes, please continue. I hope I understood correctly. I don't know because yes.
That exactly, Your Honor.
Yes.
So this case has been decided since 1935. And again, they agitate 1961, and 1961 also the EM has
Where's
rejected.
61? Where's the order? Page
36, 96.
Page Can you give the page?
27, my lord.
Page?
27.
Not a type copy, it is a handwritten copy.
27 to 31.
It was handwritten, Mr.
No, my lord. There is a type copy also. Type copy is there,
Okay.
31.
Now, what does the order say? Okay, 5661, next order. Yes.
Seen the petition 10-561, filed by Jangding Marak and 49th order of Marakapura village for recovery of Marakapura King done from Manzeng Nokma and his wife, Jedemichik of Karijora. The Aking land of Marakapura are trespassed and included with the Aking of Manzeng Nokma. The clan and his wife Michik, who was also Nangmin Jak Miklat of Karakari Aking, dated 31/7/35, passed by the then DC Karo Hill W. Shaw in Political Case number 12 of 1905, with the consent of the Maharis. Thus the matter was wisely settled up. There was no appeal then against the order passed by the DC Karo Hill. It is not therefore desirable to reopen the old case which was since decided by the DC Karo Hill. This petition is therefore rejected. In 1961 also, my lord.
This is 1961, right? Okay, fine. Next order. What is this list? Geometrical chart at page 32.
In page 32.
This is showing the list. One sang of money. Okay.
Yes. There is her name is there, right from for so many years, my lord, 1935.
Okay, next order.
Then there is a prior to that also they came again sometime in 2000. Yes, in 2000, in page 41, my lord, is there, and it's 12. Page 41.
What about this? What's Annexure 8? Okay, forget Annexure 8. What about section A9? Page 36.
Page 36 is the issues which was
No,
framed.
in which proceeding?
In the application file in page 35, if my lord see an application, page 35 is a typed copy.
Okay, you wanted to be upon Marapara.
Yes. So the issues are framed.
Okay. Right, next.
There is one mini marak here. I have another from so and so, the Mari so and so, and then the request you kindly allow your approval and issue an appointment. So against that, there is a case before the EM.
Okay, now what do you want to show just now?
Page 41, my lord.
Annexure 10 is not important.
Pardon?
Okay, annexure 10 is both the parties are present.
These positions also, I had parties of law and so and so.
Okay.
On produce of the relevant record of Marakapara King, it can be seen that the Marakapara King was already transferred and matched with a Karijura King.
Now, one second, Mr. Kiji. What is this page 40? This is appeal.
Yes, madam.
What is this order? Page 40.
That is an order objecting to for taking evidence directly without first hearing on issue of law, madam.
Okay, then next one, what do you want to show? Page 41, what is this?
41.
Okay.
Peruse the 13/9/2018, the order.
Yes.
Peruse the position of the petitioner and
39,018, okay, yes.
Yes.
Okay.
Had it the parties an issue of law and also peruse the relevant record from the file relating to the Karijura King. On perusal of the relevant record of Marakapara King, it can be seen that Marakapara King was already transferred and matched with Karijura King in the year 1935 by the order dated 31/7/35 of Deputy Commissioner W. Shaw in political case number 12 of 1935. After the merger and transfer of Marakapara King to Karijura King, Nokma or Marakapara King ceased to exist. The King ceased to exist. It is also seen from the old case record that the petitioner predecessor Jangding Marak and other Marak of the Karijura agitated for recovery of Marakapara King from one Mangzeng Nokma and his wife before my predecessor in GDC number 30 of 1960-61, and by order dated 561, their prayer was rejected by my predecessor. It is clear that the petitioner have no cause of action to pray for appointment of a King Nokma without any king, and their present petition is also barred by the principle of res judicata, as a case for recovery of Marakapara King land was already rejected by my predecessor. I therefore cannot consider the prayer of the petitioner to the appointment of a King Nokma of non-existent Marakapara King. The petition of the petitioner is hereby rejected and dismissed, my lord.
Then you come to impugn order.
Then, my lord, again,
They
this
file an
order, they file an appeal. So
Then this order dated?
Order dated 5/7/2019, my lord.
Okay.
This is an appeal has been prepared by the appellant under Rule 8.2 of the Karo Hill Autonomous District Social Custom and Usage Releasing Act 1958 for setting aside the judgment and orders passed by the EM. Had the learned counsel B. N. Sangma for the appellant and so and so. The counsel for the appellant submitted that the Marakapara King belonged to the appellant clan only, and the respondent has no connection with this king since he belongs to different king, to Karijura King only. According to the counsel for the appellant, the respondent is unable to say clearly how and in what manner the Marakapara King was acquired by her. On the one hand, she claimed that the 15 Marakapara King matched with Karijura King, and on the other hand, she also claimed that this king was sold to predecessor interest. There are many other multiple issues, and the learned CM in his order dated 30/10/2007, passed and so have directed the learned EM to hear the issue of law, but does not applicably does not preclude the landed EM and revenue from taking evidence to exhaust the entire issue that are pending between the parties. Hence, he urged the court to remand back up to the landed EM in charge land and revenue to record evidence, so that this court can appreciate the entire matter after applying the judicial mind. The landed counsel, on the other hand, submit that appeal has no merit, since the appellant Minan Marak has no right to contest the case in absence of the female person, he being only a kachi. According to the counsel, for the respondent, there are two types of issue of law and issue of fact. After framing of issue, and if any issue of law are framed, then the court can stand to hear on the issue of law and pass final order if the case can be disposed of on issue of law itself. The landed EM child revenue had an issue of law as directed by the Honorable Court of EM, and after considering that there is no case for favor of appellant, hence a prayer for appointment of Anokma for separate action was dismissed by the landed EM land and revenue. Took strong note of the fact that action will have been matched with Karijura action since 1935 by the order so-and-so of the Blue Shore. Having heard the counsel of the respective party and also after the court gone through the case, the record, including the impeachment order 13/9/2018, which was passed by the landed EM and the revenue, this court is of the view that for appreciating the entire matter, the evidence of the witnesses, since the matter is pending for long, I am the view that the statement of witness will be required for deciding the matter in hand. That is what, without giving any reason, my lord. So my submission, my lord, is that this has already been settled, and 2EM also has decided that this has been settled since 1935, my lord.
Okay, yes. Anything else to say, Mr. Day?
From my side, I have pointed out.
Just here, Mr. P.T. Salma.
I have filed my affidavit also.
Yes, here, affidavit.
Your Lordship, first my objection, Your Lordship, is actually that in that petition, first one, Your Lordship, they have given even to that respondent number 6. As per the instruction which I have even mentioned in my affidavit also, the respondent number 6 is actually she is already expired. That means here, but the learned friend, the senior, he has impleted even to that person who has already been expired. This means that petition is like defective type, because how can he implead the person who already been expired?
Then why do you file affidavit without respondent number 6 then? How do you sign affidavit?
No, we are not filing on behalf of the
this one. 2020.
Yes, we are filing on behalf of this one. But I have mentioned, Lordship.
See, you've written here right on top. Affidavit was in file 426.
Yes, actually it should have been written, but the other
so your affidavit also is defective.
But para 5 I have mentioned. Para 5 I have mentioned clearly. Of course, it is mistake, but I have clearly mentioned, Your Lordship, where it says that Lordship, if I permitted to read actually my contention para 5. 7 and
yeah, read. No problem.
Just read it, Lordship.
No problem. Read it.
And then yes, Lordship, that before responding to the petitioner, the respondent submit that the petitioner has not properly understood the facts as circumstances of the case. That she has not even properly understood the history of the Marakabra Akang and also the ancestor for parents of the petitioner, as it is evident from the record that petitioner impleaded the private respondent number 6 as Srimati Donji and Sangma as one of the private respondents, whereas Donji Sangma has expired many years back, and Srimati Donji Sangma is not the wife of Sri Molen Marak, but the Donji and Sangma was the first wife of Man Singh Marak. It is stated that, Lordship, that Srimati Donji Sangma, let me just complete, Your Lordship, let me complete, then I not disrupted my learned senior.
No, please continue, yes. You don't have to say
yes,
it.
It is stated that Srimati Donji and Sangma was the first wife of Man Singh Marak, and after the death of Srimati Donji Sangma, Man Singh Marak eloped and married Srimati Jadi Sangma against the will and wishes of Ningmanja Marak. Ningmanja Mahari. But interesting, the present petitioner is impleading Sri Donji Sangma, who has already been expired, and it is impossible to implement the dead person as a necessary party in the instant case, and moreover, it is whereby law limitation. So and so. Now, just come to the where my learned friend has senior he is thinking about that land was. There was a debt on the private respondent, and they have cleared the debt on our behalf, and that's what I have clearly mentioned in that affidavit of affidavit.
No, come to the main.
Yes, Lordship, I will come.
You answer that point only. Like
Yes, I will come.
About these technicalities, which type
The
of the
technicality
parties.
now I have that's over, Lordship. Now I will come to that meant.
How do you say that you deserve a reappreciation of this matter?
Yes, reappreciation I will come to later.
How?
Before that, I will just come to that because this one. The private respondent and their clan, that is Nengmanja Mahari, this actually, Lordship, that this land of Marakapara, it has been in existence prior to even Kazirongka. Kazirongka, there is two separate land, Your Lordship, because they have this first nokma of this one is
So you mean to say that Karijora was split again?
Rangji and Janding, yes, Lordship, because actually there was only one Akeng. But later on...
Belong to Nengminja clan.
Not Nengminja clan, but
that is
two daughter, Lordship. Two daughter, when the predecessor, there was only Maraka Para Akeng. Only Baraka Para Akeng, since there were two daughters, so the ancestors, the parents, they have given one particular Akeng to Kazirong Akeng. That is, I even mentioned in my affidavit.
I don't think the submission is correct. Because the thing is that they said that since there was no heirs anymore from Marikapara, that is why Kajigora still helped Nengminja clan. So that Nengminja, the sanctity is maintained. That's why Deputy Commissioner said merged.
We are opposite thing. Let me just clear it and read my, because I have...
You're not clearing, you're making it more complicated.
No, Lordship, it's not complicated.
Complicated some more.
Because I'm not able to express that. Sorry.
Of course,
actually, I know what actually, but then not put in a proper way. That's why Lordship is confused.
No,
because
I'm not confused. The court not confused.
No,
the court is trying to understand your case.
Yes, actually, this particular this Marakara Akeng was its existence is prior to what WSO and all this one. But later on, Yosef, as claimed by my learned senior, he said that because the private respondent has got some dues to be paid, and they, on behalf of the private respondent, they pay the money and that acquired. But Lordship, if that is to be believed, Lordship, where is the proof that they have paid the money, our debt? His claim is that they pay some debt, and since we are not able to repay the debt, so they have taken the Marakabara Akeng. That is the whole case. But now even that's the case. How to prove that? Where is that money that they have paid to the? Can my learned senior able to show that they have paid the money on our private respondent, on behalf of the private respondent, how much money has been paid? He has clearly mentioned in a petition that Marakapara Akeng was actually, he admitted there was a Marakapara Akeng, but due to the debt, because of he has not able to pay the debt, so they have paid the money and they have taken that Akeng on behalf, since we are not able to recover the money. That is now, if that is the case, then my learned senior has to show that where is the money,
So
how
that's the
much
case.
money.
Now you want to give money back to them and
We are not saying, even we are, in my affidavit, I have even stated that Lordship, page 3, I have clearly mentioned that Asim Marak and Arong Marak has, he said, borrow money from their clan, but by mortgaging the Marakapra Akeng. And due course of time, due to the huge debt, Sri Arong Sangma was not able to repay the money. Therefore, Manseng Marak, predecessor of the petitioner, repaid the loan on behalf of Arong Sangma. And therefore, Manseng Marak managed to save the Marakapara Akeng from the alienate to other clan. Now, my case is in this respect, the respondent begged to submit that the claim of the petitioner and the statement made in the petition is completely wrong, and same is strongly denied. The respondent and more by the respondent, and moreover, the respondent submitted that there is no evidence to show and to substantiate the claim of the petitioner that money was repaid by the predecessor of the petitioner. Manseng Marak, the respondent further submitted that there is no connection with the borrower of money by Arong Sangma from their clan and repayment of debt by Manseng Marak on behalf of Sri Arong Sangma, and moreover, there was no such repayment of debt by Manseng Marak on behalf of Arong Sangma, as claimed by the predecessor of the petitioner. The respondent submitted that the Ranji Sangma and her husband, Asim Marak, were the last recorded Nokma of Marakapara Akung. However, both of them expired, but Ranji Sangma has got two daughters, younger sister, namely Sri Mengri Sangma and Srimati Wanji Sangma, and one of the younger sister of Ranji Sangma and Mengri Sangma has got two daughters, namely Gasi Sangma and Ranji Sangma. Therefore, Ranji Sangma has no issue. She has adopted the daughter of Wanji Sangma and clan of Ningmanja Mahari with the consultation of Ningmanja Mahari, and with the Ranji Sangma has appointed Gasi Sangma and her husband Jadung Marak as a Nokma of Marakapara.
Okay.
As a Nokma of Marakapara.
Where is this paragraph in?
The Lordship.
This paragraph is 3 pages.
I'm reading from
Three
from
page.
page 3.
I've never seen such a long paragraph. Anyway. No, I understand your case. Yes. What
Yes,
else you want to
the,
say?
the respondent submitted here.
So you say now, just from what I understand, that nothing is settled. Now the very fact, the basis of the entire the Marakara Aking being extinguished is wrong, because there was, I mean, it should not have been extinguished, should not have been merged with Kharejora.
Yes, sir.
So that means that on that ground, there are very good grounds that Marakapara should be resurrected.
Yes, Lordship.
And be given its independent Nokma.
Independent
because
Nokma.
the line still exists.
Yes, Lordship. Because we have no problem with the Kaziranga.
I understand, but then just one what is taken away from you, give it back to us.
Yes.
And let us be the right.
We are saying let them be the Nokma of the Kazipong. We have no problem. But they should not. We should allow us since our main claim is that the Marakapara has been since existence since.
Questions. Yes.
Your Lordship, my point, Your Lordship, I mentioned also in the affidavit, in the 1995, my learned senior, he has made a submission, he even admit also, that saying that there was an order and not, to that effect, we are submission, Lordship. Since from 1935, the Maraka Parang, there was only one Akung, as I have stated, Maraka Para Akung, there was only Akung, but was equally divided into two parts. That is, Maraka Para Akung and Karijora Akung. There was only one Maraka Para Akung, but in 1935, they have divided because there are two daughters, so they wanted to sell this one, and they have make it separated. Then one Kajirunga Akung, this Karijora Akung is actually, it was derived from the cut out from the Marakapara Akung only. We have mentioned also. Then and accordingly that
understandable, because it's that if both Akang belong to Ningminja clan,
both Akang Ningminja clan. But now only the problem is that since from the predecessor of the Akang, the petitioners, they say that since now they wanted to take hold of the Marakapara Akang into Kajiroka Akang, saying that the Marakapara Akang does not exist. They wanted to even take hold of the plot of land, actually, which is given to, because this parents of the, because the petitioner and the respondent, they were sisters. They were sisters. Then the parents, they have divided the land. You one portion of land, you take it. The one particular portion, you take it. When later on, they said that they wanted to take it whole thing, because that's why there was a, even learned friend admitting, they said that there was only Marakapara Akang. Then from Marakapara Akang also, since from 1935, there was a separate Nokma. And Kajironga also, after cutting out from the Marakapara Akang, the Kajironga Akang has got a separate Akang Nokma. So after some years, Lordship, they wanted to merge, and they say that there is no existence, there is only Kajironga Akang, there is no Marakapara Akang. That was the whole case, Your Lordship. That's why there was so many continuous of process, and then there was a file, and my learned friend, if we go from the record, it says that whenever they want to take the evidence, the petitioners, they file an objecting that it cannot be done, because they said they are only claiming this case settled, and they even want to frame the issues. Rightly or wrongly, my learned friend has already found out when there is a court, when the petitioners file before the court, that the logical calculation has to be there, and then some sort of the guideline, the procedure, like my learned friend has make a mention that Doris Sangma, those maybe I submitted my learned senior, even if there is no existence, even that proper conclusion, logical conclusion as per the law and the procedure, that has to be there. That is, but from the record we'll say, when the EM wanted to take the evidence, they said we don't want to take the evidence. And the EM even saying that we want to frame the issues, they don't want to frame the issues. Then when the EM want to put it in the, maybe it will be in their favor, in our favor, we're not, but yes. Objecting that even in the last preparation, that BM only says that let the evidence be taken, the proper procedure has to be followed, let a frame the issue, recorded the evidence. Even they don't want that one, because this one actually, this order itself is incomplete, because they said that the order only says that go back to the EM.
So your submissions that notwithstanding any facts that were prevalent before the proceedings, once it comes before for adjudication, that it should be go to logical conclusion.
Yes, logical conclusion.
Okay. Suppose Mr. P.T. Sangma, he had bought a house which was a dispute. Okay. Then the house in dispute, then there was a suit, title suit, and then court decided in favor of P.T. Sangma that that this land belongs to declaration of title, that it belongs to P.T. Sangma. He has clear title over the land by virtue of
no, my case is
now
that,
listen.
Yeah, Lordship.
Now that's over. You're enjoying. You're staying in your house. One fine day, the same fellow comes again. Says, no, that land, that part's wrong because he didn't have a daughter or this and that. So that portion, that land, that house does not belong to him. And so proceedings filed before the court. And then the other side, now you go and say, how can it be? Because it's already decided. See, this decree is in my favor. Then I said, no. So what decree? Once you file in court, has taken logical conclusion. Can that be the submission?
Yes, Lordship,
Yes.
actually, at the first instance, Lordship, they have wrongly or wrongly that case has been admitted. And
Okay.
as I said that there was a continuing process, Your Lordship.
Any authority you have to support the submission?
Lordship, before passing any order, before because it's
No, we will-
on our part just to inspect the document also then after that, because
What document to inspect?
they have already produced this
We'll
case
see the
record.
records, no
We will
problem.
see the record also. Then after that, something also might be there because
We will pass orders in open court so you can assess the court also. No problem, yes.
The record he cannot examine. My friend cannot examine the record.
No, it's- See one thing, Mr. Sangma, you are repeatedly going to the district council. You want appointment of acting Nokma, correct?
Lordship.
You say that all these appoint acting because Marikpara acting
Marakapara.
is yes, Marapura.
That is there. Since it is on fact, on record, that there was a Marakapara Akeng was there since from 1935.
Yes.
And from there only they divided. From Marakapara Akeng, two Akeng divided. Khari Jora, and the parents Akeng is the Marakapara only.
Okay.
That is a core keys. And moreover, at that point of time, how can we expect those people, they are not able to read and write also, they don't know even the law and or just, some petition might have passed and these people, they may not receive the proper notice, that at that point of time, 1995, so 35, so pre-independence, we cannot expect that they will know all these procedures, this notice, and after some years they might come to know. These things has to be looked into, Lordship. Even the Administration Justice Act is come in the year, somewhere in the year 1958 only. That was even prior to that.
Doesn't matter, prior to it also, it was custom is custom.
Yes, Lordship, custom is custom, then...
Customs codified after Social
Lordship,
Liability Act came
Lordship,
after 58.
No,
Fine,
no.
then custom was codified, and then who was an aking,
Yes,
how was
that
Nokma dispute.
Custom was there, but only by that regarding the procedure and such, because my learned friend after so many years, they not coming and challenging that was the case. That's why I'm just telling a reply.
Take down. Monument champion. Yes, this writ petition is directed against the order dated 5/7/2019, passed in take down GHEDC Revenue Appeal number 9/A/C capital of 2018 by the respondent number 2, Chief Executive Member of the Garville Town District Council. The grievance, next para, next sentence. The grievance of the writ petitioner is that by the impugn order, an issue which has been decided is sought to be reopened by the respondents. Which would lead to a reopening of proceedings which had been finally concluded as far back as in 1935. So, Next paragraph. A brief narration of the facts is that there existed a king known as Marakapara, Marakapara king, which originally belonged to, you kindly help Mr. Secretary, to belong to one Ranji Michik, Ranji-Mechik, of Nengminji clan, Nengminji clan, and late Asin Marak, Esin, Marak of Morong clan. Stop. From the facts as placed, it appears that a huge debt was incurred by the son of the aforementioned persons, who mortgaged the said king. Boleh king? Tak no boleh? It appears no. What one Arong Marak, Arong Sangma. Nota? Yes, leading it to the brink of it being alienated. Stop. Thereafter, this matter came to be adjudicated by the Deputy Commissioner Garu Hills in a political case being political case number 12 of 1935, wherein the said Arong Sangma of Marakapara Aking was arrayed as the opposite party. Stop. When the matter was pending, before the Deputy Commissioner's Court, the question of succession to the said Aking also arose. Inasmuch as two daughters who were to be successors in interest namely that's who Gasi and Rensi Marak, namely one Gasi Mechik and one Rensi RENSI Mechik, were married to persons belonging to the Chambugong clan, CHMBUGUNG clan, which was not approved to by the Charas and Maharis. Stop. Stop. With regard to the said loan amount, which had been taken by Aurong Sangma, one Sri Manseng Marak, one Sri Manseng MNSM Marak. If I'm wrong, please correct me, Mr. Kinjing.
Yes, sir.
I'm just from his submissions. I'm just trying to recollect. One Sri Manseng Marak,
I'm also checking.
who was married to one Jade Michik, GEAD Michik, who was a Nokma of and the adjacent, it's very important, Khari Jora Aking. Repeat the said amount. Stop. Stop. As such, in the situation where the successor daughters, the two successor daughters, were married to persons belonging to another clan, namely Chambukang clan, which did not find favor with the Chachis and Maharis. And in view of the fact that the land was saved by Shri Manseng Marak from being alienated otherwise, the Charas and Chachis were in favor of giving over the said Marakapara Aking to Mansang Marak, who was the Nokma of the adjacent Aking, namely Kharijora. Stop. Thereafter, the Deputy Commissioner, by order dated 31/7/1935, declared, merged the two Akings and ordered for preparation of accurate boundaries, showing the merger of Marakapara Aking and Karijura Aking. Stop. The next paragraph. Mr. K.S. Kinjing, Senior Counsel, on behalf of the writ petitioner assisted by so and so, submits that with the adjudication of the matter and in view of the lack of successors, to preserve the property, to preserve the Aking, the Charat and Chachis, Charat and Maharis, or Chachis and Maharis can write, were in favor of the said merger, which was duly noted and recorded and made an order of the court by order dated 31/7/95 by the then Deputy Commissioner. So, Learned Counsel has referred to the order in question and submits that the same being a final adjudication, the matter was set at rest. So I'll refer to the order. Problem? He further submits that though this was the position in 1961, where is that, Mr. KG?
Page 31, madam.
31?
Yes.
In 1961.
31. This was a settled position as regards the Aking, comma. On 10/5/1961, one Sri Janding Marak, GNG Marak, and Srimati Jangde Mechik, GNG MEC Chaike, filed an application before the EM in charge revenue, GHADC, for recovery of the Marakapara Aking, which they alleged was under the custody of the said Manseng Nokma. Stop. The court of the EM in charge of revenue, then he submits, then by order dated 5/6/61, dismissed the said application since it was a settled matter and
that no appeal had been ever preferred from the order dated 31/7/1935. Stop. When they came again, Mr. Gini?
That order is in 4142, my type copy.
No, not 4142, not the last one, not the CM's order. Oh, yes, yes. Leonard Singh submits that thereafter there was a further attempt by one Sri Minan Marak to again re-agitate the issue. Which matter was dismissed on 13/9/2018. No, after that last sentence. See you. To me, okay, take on select. If you don't see him, I'm going to say you. You don't get it, tell me. We tell me. You don't Kumar. I see him. Minion Marak. MINEN Marak. By 1 million Marak. (2018) by the learned executive member in charge, Land and Revenue. Against the said order, he submits an appeal was preferred. Which was disposed of for the direction that the EM charge revenue fixed the matter was directed to appreciate the entire matter by taking evidence of witnesses and so on. Stop. Legal Sales Counsel, talking that this matter being squarely barred by the Conference Data, apart from the antiquity of the order from which the respective rights of the parties had been settled, the impugn order suffered from grave irregularity and was bad in law. Stop. Next, Mr. D, what do you say?
I have 2 points, my lord, where I'm questioning that the property which was mortgaged, whether the NOCMA has the authority, there is a settled law, my lord. The property of Aking property, my lord, cannot be.
Whether the Charas and Chachis have anything to say with it, they would not have a say.
Two things, my lord. One is that the property of the Aking cannot be mortgaged by the NOCMA for his own debt, my lord.
Yes.
There is nothing to show that the debt was of an Aking. Second part is this, my lord. If the daughters get married out of the
clan,
like not from their father, it is not that Cha and Chachis will have any saying on that, my lord. It is the mother, my lord.
Ms. SD, on behalf of the official respondents, GHDC, submits that the basis on which the merger was done is not as per Garo customary law and practice. Inasmuch as, firstly, a Nokma possesses no right, customarily or otherwise, to mortgage an arking for personal gains. And secondly, your other point is other clan. And secondly, even you're saying you're sorry.
The daughters, by virtue of getting marriage,
Yes.
whether they relinquish their right.
Yes, and that there's no question of the rights of the successor daughters being extinguished just because they have married outside the clan from which the Nokma is selected. Next, Mr. P.T. Sangma, another counsel for the private respondent number 4 and 5, has submitted that, leaving aside whatever proceedings that had occurred prior to the pending matter before the CM, the case should have reached its logical conclusion to determine the rights of the contesting parties. Stop. He contends that the objection by the petitioners at this stage is premature because there is yet to be any final order passed by any authority in this present proceeding. So, apart from tracing the history of the Magapara Aking to try to impress the court that the issue is still alive, he submits that the matter be remanded back for adjudication as per law and in the light of the principles of judicial procedure and the light of fundamental principles of judicial procedure as prescribed by the case of Dore Sangma. Stop. Next paragraph. Heard learned counsel for the parties. Stop. It is first to be noted that this matter is not before this court today. On the interpretation of custom and as to whether the arrangement arrived at by the first order dated 31/7/1935 has been based on the interpretation of correct custom. So, stop. Within a limited compass, in the considered view of this court, the challenge of the petitioner is based only on the fact that a matter that has been settled for over 80 years and where competing rights have been apportioned, cannot be allowed to be dug up and the fact we put up a reappreciation. Just because the respondents feel that just because another period, and just because before that, no? For over 8 years.
Where competing rights have been apportioned cannot be allowed to be dug up
and re-agitated on the whims and caprices of the respondents. So, this court has examined the order dated 13/17/1995. And the relevant portion thereof last two paragraphs is reproduced herein below. So, a perusal of the extract quoted above shows the finality in the proceedings, inasmuch as it has been categorically held that the King of Marakapara was given to J.D. Michik, who was of the Neng Minja clan, Neng Minja, N-E-N-G-M-N-G clan. They say not meaning. They say but you can't say sister clan of what's this Karigora, because the same. It's what to say because it was held that there's no heir anymore. There was not been held. There's no heir anymore from this Marikapara. So it's given to, and then given to J.D. Mechik, who's of Ningminja clan. She's the Nokhma of Ragib, of this Karigora. Yes, and belongs to the Ningminja clan.
Amalgate, my lord.
Yes, which would come within the same clan, and as such would preserve the clan's property, the clan's king. So, next paragraph. As submitted by the counsel for the petitioner, the matter was sought to be re-agitated again in the year 1961. But the same was rejected in view of the final order dated 31/7/35. Thereafter, another attempt in 2018 was rejected by order dated 13/9/2018 by the executive member in charge land and revenue, holding that the prayer had been earlier rejected by order dated 5/6/61 and was also barred by the principal affairs educator. Stop. Next paragraph. The impugn order, however, the impugn order, however, whereby an appeal was taken, was preferred, against the order dated 13/9/2018. On a bare perusal of the same, or on a plain reading of the same, has in a manner reopened the dispute by directing that the same be reappreciated and evidence of witnesses be recorded for final decision. Stop. Next paragraph. Looking to the entire sequence of the events, though valid arguments may have been raised with regard to the interpretation and application of customary law at the time when adjudication was, at the time when the matter was heard by the Deputy Commissioner, the undisputable fact, however, that cannot be ignored is that categorical findings had been arrived at, and no appeal had ever been preferred therefrom. The antiquity of the order being of the vintage, the antiquity of the order being of the vintage of 31/7/1935 attains a significance in as much as at this late stage there can be no question of the same being reappreciated or re-examined to arrive at any other conclusion than what has been decided therein. Stop. Next paragraph. The subsequent challenges made in 1961 and in 2018 have also been disposed of by the successive executive members in charge of revenue in a correct manner. Stop. Correct manner. But the impugn order, by allowing the re-examination of such an issue which has long been settled, is squarely hit by the principles of res judicata. The submissions of the counsel for the respondents, the due process or fair trial should be allowed, is of no relevance or consequence when looking at the facts and circumstances of the entire case. Stop. Para. In this view of the matter, there being no merit in the incident petition, in this view of the matter, the impugn order stands set aside and quashed, and the writ petition stands allowed. No orders to cause. Take back the records.
(22)
What is this?
Your Lordships.
You don't have your opponent.
He's there, my lord. He'll do it. We'll just now met him. He's coming.
Yes, call the other matter first. What the other pass over matter order matters? Where's the pass order matters? Do contempt.
Second call, 5.
Nursing assistant.
My lord, here it's the affidavit has been filed so callously in every paragraph. Writ petition.
Cost to be imposed.
My lord, so it's does it not another violation of willful? So I may be allowed to file a reply of this to bring on court.
But let them come contempt between the court and the where's that? Where is Mr. Dr. Muzika? So, Mozika, what is this? What kind of affidavit is this?
Affidavit filed by DG.
This one?
Where's the affidavit? Mr.
A mistake.
You see the affidavit file? Where's the affidavit file by the? That is the file on
3rd May.
Look at para 1. Article writ petition. Then,
my lord, para 7 writ petitions. Every para's writ petition. And para 13, my lord.
Writ petition, the word name merit.
Dismiss. My lord.
A small, I'll do the correction.
My lord, that cannot be. My lord, now the affidavit and verification, my lord, can come. Affidavit and
verification.
30th April. And the verification is on 3rd May. It is signed blank paper and then printed out. It's a callous approach by the contemptor number 2. Total non-application of mine, my lord.
How can the affidavit be replied this
What
way?
more?
I'll correct it, my lord.
This is not done.
It's a contempt, my lord. Can't be corrected, my lord. It's an affidavit where he has to go in jail, my lord. The DG Assam Rifle.
Go inside jail or just go to the jail and come
To
back?
the jail, my lord. He has
Inside
to
the jail.
He has to go filing
Yes.
this type of affidavits, my lord.
This is
Swearing this
contempt.
type of affidavits, it's totally unwarranted by the callous approach.
Those clerical errors, my lord. I'll rectify it, my lord. But other-
Why
but-
this affidavit 30th April
Because
and verification?
Because what happened, my lord, we prepared and communicated to them in April, my lord. Maybe there was some delay. In the meantime, May started, my lord. So, April they had to change to May, my lord. Ma'am, also that can be, I may be allowed to correct, my lord. It's a minor type of rebel. A clerical
Then why
error.
this? Why who does the affidavit? This petition. Absolutely callous.
Well, I pray for apology for that.
Actually, Mr. Jha, it's not the deponent's fault. It's a.
But on merit, my lord, if you will also permit me, my lord.
Correct this one, no merit business.
I'll correct it.
Otherwise, this time we'll ask the DG to come personally.
Yes, sir,
due to the
mistake on my
due
part.
to the defects that are appearing in the contempt application, the learned senior counsel prays not to correct the same. So praise allowed list after 1 week. Corrected them. This thing is not be done.
7. 7.
On the last occasion, a shelter was taken of the division bench order, which
What
had given
happened,
them 3
Dr.
months'
Mazika?
time. That expired in April.
But I'm praying for some more time because I've not received any instructions. Because that time period just expired, my lord. Within 10 days, I'll take instructions. If we have to comply, we'll comply.
Of course, you have to comply.
Unless there is something.
If there's something, you should have come on court by now.
Right.
The question of three is you have to file and an affidavit should bring a
Respondent number 1 is yet to file an affidavit. Respondent
Forget
number 1
about
has
that. They let them come first with the affidavit, then we will fix the responsibility. So sometimes you can't have hot and cold, hot and cold.
Taking cue of the division bench, it was stated that 30th April we have the last time. So therefore, Lordship have fixed it after 30th of April.
My lord, but the true purport of the division bench's order is, my lord, that vis-a-vis that particular case, my lord, where the order is passed, there a decision has to be taken within 3 months.
So therefore,
but as far as revised policy, there is no deadline given by the division bench also.
So therefore, they had to comply with the existing policy. If we take that argument, they have to take the existing policy.
Yes.
Nothing to do with the revised policy. Why was time taken on the last day?
The Honorable Division Bench has held, my lord, that it is a fact that the policy is under reconsideration, my lord.
See, whatever it is, Dr. Mazika, when it affects, it has a bearing on this case. You cannot say that it's totally divorced of that or the particular fact that case. If it concerns a certain policy which involves a certain set of people who are governed by that policy, you can't say that in the case of Mr. A, that order was passed won't apply in case of Mr. B. Then there won't be any judicial discipline also, that means. It's like that. Even you heard about vertical, horizontal, diagonal, discipline you talk about now. Vertical top to bottom, horizontal, other, committee of courts, like they say. All the tribunals do that. Diagonal means, suppose IT, a tribunal income tax tribunal in Bombay will rely on decision passed in income tax tribunal in Calcutta. And see, this is the position being held in a certain particular case. So that brings about a kind of otherwise Supreme Court would be burdened with. I mean, if every court single bench sitting doesn't apply to this case, that applies only to that case, starts passing the order, then you can imagine situation what we will be faced with. I mean, and all the matters go to Supreme Court and you file all appeals. The Manipur High Court passed like this, Meghalaya High Court passed like this, Tripura High Court passed like this, Gaudi High Court passed like this in one matter.
That is happening, madam.
It's happening because of that, because they have to be horizontal, they say, okay, vertical is fine, precedent, Supreme Court comes to High Courts. Horizontal is other courts also, they have to take into consideration the judgments for other courts. And if income tax tribunals, they're doing diagonal also. I mean, even diagonal means that they're going from a tribunal passing here, they're accepting that and say, okay, this is the position of the department.
But the difficulty is because
that is what we've seen.
Because what is taken that judgment of a different high court only has persuasive value. That is creating all difficulty.
Even
in this case, every high court has upheld this policy decision. Every high court, even the Delhi High Court now.
No, yes, everyone says persuasive value, fine, persuasive value. But even to that extent, we feel that judicial discipline also is necessary. Not discipline means that uniformity.
In fact, I sent them a very strong mail, my lord, just 10 days back, but they have not responded.
It was not strong enough, the mail.
I think it was strong enough. Only abusing was left, my lord.
We just give them some time. Then Dr. Mazika submits the praise that he made out 1 week further time to appear instructions, 10 days for the transactions. Yes.
Oblige.
Not yes. Though objected to by the learned counsel petitioner, praise allowed.
Oblige.
Supplementary, item 1.
My senior will appear through VC.
Will appear through?
Through VC.
But he's not appearing as yet. Yes.
So, my lord, in this case, the petitioner as the caretaker of a shrine has all along been holding the annual fair. This time when he obtained the permission, page number 22, annexure 5, my lord. Permission was granted to the DCA as all along been done.
Page?
22, Annexure 5, my lord.
Sorry, yes, okay. Yes.
So permission was granted for holding the affair on 7th May, 14th May, and 21st May and 30th April, on 4 days. So, my lord, the respondent just filed an miscellaneous application under section 151 before the assistant to deputy commissioner and got it stayed, my lord.
That means one date is gone, the 30th April is gone, 7 May is gone, 2 dates of Dargah are gone.
Yes.
Now you have
Yes,
14th and
yes.
21st.
Yes, my lord. So, an application was submitted under section 1.
No, under what, see, under what provision is this permission granted?
Permission is granted on the law and order situation or administrative, on the administrative side, my lord, not under the law. So an application was made by page 24, Annexure 6, my lord.
Yes.
Under section 151 to the Assistant DC. See, my lord, application in behalf of the petitioner under.
But is it in a pending title suit?
A long pending, my lord, about 20 years back, case is pending there. And in that case, an application was made 151 without making the deputy commissioner as the party, and they obtained an order staying the operation of this order, my lord. So at least section 80 will come into play if they want to file a petition under section 80.
No, one thing let us understand, Mr. Siddiqui, is that are you fighting over the shrine or fighting over the Mela or Dargah?
Only Mela, my lord. So far as the shrine is concerned, that is another thing. And my lord, please come to the
court
judgment.
won't pass orders just without hearing. Other side, sometimes you say that they take cover of the order. Suppose this court stays order, you go and take over the shrine if there's some dispute over the shrine. They'll lead to a law and order situation. Yes?
No, my lord, that is not the thing here. Please come to section, page 32, my lord, of the order. Page 32 of the MP order.
When's the next date of the Dargah?
For the Mela, it is 14th May, my lord.
We are now, today is 8th. We'll take up tomorrow.
Tomorrow, please, 32.
Tomorrow. And item number 1, submitted list. This Jyotsna Bewa is not a regular litigant in this court. This name seems familiar.
Yes. Many times it came to High Court. Yes, ma'am.
Who's the counsel who appears? Mr. Sheikh? No.
No, sometimes many lawyers have appeared in the, I don't know who will appear in this.
Not possible to serve them one day, no?
It is
by email?
By
email?
Email to in a village, my lord.
Listen tomorrow. Since you still have some time, listen tomorrow. Motion number 1, yes. That we just go through, because these matters are very sensitive. Suppose some orders pass right now without examining the background, might lead to.
Sure.
Yes. You ready, Mr. Bharataji? No.
It's okay. We'll do it.
It's okay. How long will it take, Mr. Sen?
No, not so much, Your Lordships.
What other matters are there? Does transfer matters are there? Let's take up first.
It may come at the end of the bottom.
Let's take up.
23.
Who's in order in the transfer matters? Huh? 23. Okay, just about 23 because
23.
I think other lawyer is not ready for the matters.
Your Lordship, if Your Lordship can fix a short date for this matter, because Mr. Philemon Umpri is on his legs in courtroom number 3.
When? 2 weeks, okay?
Yes, Your Lordship.
1 week or 2 weeks?
2 weeks, Your Lordship.
2 weeks in the prayer council is 1 yes, 24.
24.
I'll leave my Lordship.
24.
Please, Your Lordship, I'm appearing on behalf of respondent number 4, and I'll be filing an application to recall the order dated 21/3/2023, Your Lordship, in the course of the day.
For what?
for
Affidavit closed.
Lord, initially what had happened, the private respondents have never appeared. Then the case went ex parte. Then my lord almost reached the hearing stage, and I think on the last occasion they entered it.
When you file application, we'll allow you. We'll consider it just after 1 week. Yes. So your name?
They've given a copy.
I'll be filing in the course of the day.
No matter Adi Hashing, Leonard Counsel for the respondent, please will have to file application for recall of order dated
21st 3/2023.
21/3/2023. Yes. Prayer allowed list after 1 week. Yes.
25.
Lordship, this is a promotion matter, Lordship. Promotion matter. Lordship,
We'll take long because we take up Mr. Sen's matter first. We'll see other matters will need to be adjourned. That's why.
Well, this matter may pray for some other time, not after 10 days.
10 days on the prayer of the DHI. 26.
26.
Nobody. None for a petitioner list after 2 weeks. Yes. What will transfer matters?
27.
27 to. Yes. Can we fix one day, Mr. Borisaji?
According to me, when a division bench judgment to take care of everything.
No, they have some.
At least
we have to hear them.
No, it's definitely.
With your permission, we'd like to give small sufficient for that. Nothing else. We'll see the next day after 2 weeks.
Only thing is that these trials are all.
Yes, that's what. They can't be stuck. We'll have after 1 week then.
Yes.
Because this court won't be available after, after 2 weeks won't be there.
Yes.
So we'll fix it. We'll fix it on. See, can you fix on 15th as a fixed matter? 15th of May. Is that all right?
Yes.
I'm looking at June. Sorry. Now it's 8th. No, we'll have 16th of May then.
16th.
Tuesday we'll have less matters. Yes. Monday yes. This is matters. Let's fix matter on 16th of May.
Obligation.
I live like. Amanda,
22.
Wait, please, your lordships. My lord, this is the main issue here is, my lord. Though the
half an hour.
Yes, half an hour. I'll complete my lord, half an hour only.
Yes.
Because I have jotted down the relevant point, my lord. So there is confusion. No, admittedly, my lord, the government of Meghalaya, my lord, adopted the UGC norms, my lord. Now, what happened, my lord? Let me briefly explain. Now, after every 10 years, my lord, central government carry out what is called, my lord, the pay commissions. Now, what happened to the teachers, central government? It's not the same as central government. Simultaneously, my lord, UGC in consultation with that point of time MHRD, now I think, my lord, Ministry of Education, they carry out a separate exercise, my lord, and they provide what should be the pay scale of the teachers in Central University, of course. What should be their designation? From time to time, they change the designations. Then what should be the qualification for recruitment of the teachers? So all these with the purpose, my lord, to enhance the quality of teaching, your lordships. This is the purpose. Now, my lord, we are concerned with the, my lord, 6th CPC. Now, what happened, my lord, 6th CPC, which central CPC, my lord, which became effective from 1/1/2006, my lord. Now, what happened? Following the Central Pay Commission, my lord, the UGC took up the exercise along with the MHRD, and they formulated a scheme. Now, that scheme, my lord, dated 31/12/2008, my lord. Now, it is quite voluminous, and the scheme itself say, my lord, that on the line provided in the scheme, the UGC will formulate made a rules.
Just come again, sorry. You said that 6 CPC, what did it mandate? You said that along line 6 PC, the rules should be made.
My lord, 6 CPC became effective from 1/1/2000. That is, I'm talking about the central government.
1/1/2000?
1/1/2006. It became effective.
Okay.
1/1/2006. It becomes effective, your lordships. Now, following the 6 CPC, my lord, the UGC along with MHRD, my lord, took up the exercise to determine the pay scale of teacher of the central, which is not provided in CPC, central government's pay commission's report, my lord. They took up an exercise and, my lord, they formulated schemes providing what should be their pay scale of the central university teachers, then what should be their education, what should be the designation of teachers. All
for
these
central, this is for all central universities.
Obviously, my lord, for central government university. Now, my lord, this scheme is dated, my lord, 31/12/2008. 31/12/2008, my lord. Okay. Being voluminous, my lord, I could not, my lord, annex the entire thing. And I made a prayer, my lord, that I would rely on the UGC rules. Because this scheme form a part of the UGC rules, your lordship. And last time, my lord, my learned friend did not have a copy. I supplied him a copy. I supplied.
You got a copy now, Mr. Bhattacharya?
Yes, yes, long before. Not last occasion, before that.
That's a small issue, doesn't matter.
Now, my lord, lordship will, my lord, come to page of this compilation, my lord, rules 7922.
You be
7922 page.
Page 792.
792, my lord. Now, my lord, this became effective from 1/1/2006. Now, this provides what should be the central government, all regarding central government, my lord. No?
One second.
7922.
Some are page numbers, some don't, that's why.
On the left hand side, your lordship. On the left hand side.
Yes,
The lordship.
7921.
7922.
It's set 31/2008.
Exactly. This is the scheme. Now, if your lordship comes to page 7935. 7935, my lord.
Yes.
Your lordship has got it. Now, in the bottom, my lord, under clause, my lord, P, applicability of the scheme, my lord. Applicability of this. The scheme shall be applicable to teachers and other equivalent teachers of library and physical education in central university, colleges they are under, and the institution deemed to be universities whose maintenance expenditure is met by the UGC. The implementation of the revised claim shall be subject to the acceptance of all conditions mentioned in the letter as well as regulation to be framed by the UGC in this behalf. Universities implementing the scheme shall be advised by the UGC to amend their relevant statutes, ordinance in line with the UGC regulation within 3 months from the date of this order. Number 2, my lord, the scheme does not... Lordship.
Applicability of the scheme, right?
Applicability of the scheme, my lord.
Okay.
So this 2 is also not relevant. My lord will come to next page, clause 4, your lord, subclause 4. Sorry, my lord, subclause 5.
Okay. 5.
Subclause. This scheme may be extended. Next page. The scheme may be extended to universities, colleges, and other higher educational institutions coming under the purview of state legislature, provided the state government wish to adopt and implement the scheme subject to the following terms and conditions. Now, A, my lord, regarding the financial assistance, 80% by the central government,
okay,
20%.
Clause 5.
Lordship.
I mean, no, one thing, Mr. Sen. So this prescribes the scheme. And the scheme for?
My lord.
1 second. You said 4, I wrote 4, then you said 5.
My lord, I'm sorry, 5. Roman 5.
That's why I'm using a pencil.
I'm sorry.
Yes.
My lord. Now,
what reading now you say? Clause from clause 5, that means you say
this extends to the
which one, which was the sub clause which you are referring to?
No, sub clause, my lord, sorry, my lord. The main clause is I am referring to is clause P.
No, P, okay, if you finish with P, 5. Then comes to clause 5. Then what's other clause of
F?
F, okay, F,
my lord, I'll just read it, well, this is important. State governments taking into consideration other local conditions may also decide in their discretion to introduce scales of pay higher than those mentioned in the scheme and may give effect to the revised band scales of pay from the date on or after 1/1/2006. However, in such a case, details of modification proposed shall be furnished to the central government and not to any higher central government, and central assistance shall be restricted to the payments as approved by the central government and not to any higher scale of pay fixed by the state government.
Read slowly. State governments taking consideration other local conditions
may also
decide in their discretion to reduce scales of pay higher than those mentioned in the scheme. That means they have liberty even to give higher pay.
Higher can, but not
and
below
may
that.
give effect to revised bands pay scale of pay from a date not on after one. However, in such case, the details of modification shall fund central government, and such system shall restrict the pay bands as approved by the central government and not to any higher scale of pay fixed.
State government will not, central government will not take the burden. State government has been given one liberty to deviate if they wish to.
The one pay band that you're giving, the central government will pay for that.
Yes, if it is as part the UGC, my lord, that 80% will be borne. But if you want to give higher, state government is at liberty, but not lower. Higher, then you bear the expenditure, but you are at liberty to do it. So, my lord, next, G. Pay of central assistance for implementing the scheme is also subject to the condition that entire scheme of revision of pay scale, together with all the conditions to be laid down by the UGC by way of regulation and other guidelines, shall be implemented by the state government and universities and colleges coming under the jurisdiction as a composite scheme without modification, except in regard to the date of implementation and scale of pay as mentioned herein above. So they made it very clear, my lord. These will be subject to strict compliance with all the conditions laid down in the UGC regulations and the schemes, except of course, if they wish, what I have just stated, my lord, a higher scale they can prescribe, for which they will have to bear the expenditure, not the central government, and the date of implementation. The date of implementation, normally the central government say 1/1/2006. Now state government can take another decision some other date, my lord. These two liberties were made available, no other liberties. They are bound by otherwise, my lord, in respect of others, by the scheme, by the regulations. Now, my lord, I'll take your lordships to Government of Meghalaya's decision, my lord.
So now the basis is that UGC 2010 CPC implemented from 2006. Now 7922, that 31/12/2008 notification. 7th clause P, applicable to the scheme, and clause 5 F and G. Okay, fine. You pay higher, your headache. Pay band should not go lower than that. That's why 80% is borne by the central government.
But I'll clarify one thing. So for the state government, my lord, they have not prescribed any higher pay scale. They stick to the pay scale of the central government, UGC only. So that issue is not coming. Secondly,
will never come. Which state government will give higher?
Other thing come, 1/1/2006. They are also, my lord, Meghalaya is also following 1/1/2006. So they have not.
2006 means date of
giving
date
effect
of CPC.
Yes. So they are also following 1/1/2006.
Yes.
Now, your lordships, I'll take my lot to 7910 of the same compilation. Now, we are assistant teachers, my lord. We have been redesignated as assistant teachers. Now, my lord, what would be the pay scale of assistant teachers is provided in 7910. Schedule
7910,
my lord.
Scheduled pay of
schedule
teachers.
for clause 6.8.0. This is for pay scale, designation and stages of promotion under CAS of the incumbent newly appointed assistant.
Let me just go to that page.
7-9
coming apart also.
Lordship, Lordship can take this one.
No, you get it
better,
spiral.
better.
No, this get it spiral bound. No, it'll be.
This is spiral bound, my lord. This is Lordship
No,
can
it's
take.
all
No
right,
problem.
it's all
Because I'm very familiar with this. I'm very familiar.
You know
with
it by heart.
I'm familiar with. Because we have done, I mean, so many things.
No, not that.
No. This Lordship I can refer to, no problem. Because I'm sorry, I think some notings and all that. Actually, this was meant for your Lordship. I don't know. Somehow.
The one we have in the copy doesn't match.
Page numbers are not telling you, man.
Okay, where were we?
7910.
Okay. This is better. Yes.
7910, my lord. This is regarding the pay scales, my lord, for assistant, assistant professor, associate professor, etc., my lord. Now 1.0, my lord, deals with assistant teachers. Now we assistant professor, we are assistant professor. Person
entering the teaching profession in the universities and colleges shall be designated as assistant professor and shall be placed at the payment fee of rupees 15,600 to 39,100 with AGP of rupees 6,000. So lecturer already in the service of the previous pay scale of such and such shall be redesignated as assistant professor with the said AGP of rupees 6,000. Their CAS promotion would be subject to API criteria based on PBS system norms laid out in these regulations. So what they are saying, my lord, the assistant professor entry level after revision, my lord, he is entitled to payment fee with academic grade pay of 6,000. So this is the initial pay, your lordship. Now lordship will come to number 2. An assistant professor completed the service of 4 years possessing PhD degree in the relevant discipline shall be eligible for moving AGP of rupees 7,000. So my lord, these are the conditions on if a assistant professor is holding PhD degree, my lord, and 4 years of service, then he would be entitled to move to the next higher grade of AGP, that is 7,000. Now, my lord, 1.2, an assistant professor possessing MPhil degree or postgraduate degree in professional courses approved by the relevant statutory bodies such as LLM, MTech, etc. shall be eligible for AGP of rupees 7,000 after completion of 5-year service as assistant professor. This is another move, my lord. Those who are possessing professional degrees and MPhil, your lordship, how they will move to 7,000. Now, my lord, 1.3, this is yet another
AGP they start at 6,000.
6,000 with an opportunity to move to 7,000, then thereafter to 8,000.
Yes.
Multiple opportunities are there. Now, 1.3, if your lordship come, is say an assistant professor who do not have PhD or MPhil or master degree in the relevant professional course shall be eligible for AGP of rupees 7,000 only after completion of 6-year service. In that case, man, you do not have any professional degree,
No
you
problem.
have to complete 7 years, then
But
you will move
the
to
qualifying criteria is 6 years.
6 years, my lord. Now your lordship will come to 1.4. The upward movement of AGP rupees 6,000 to AGP 7,000 for all assistant professors shall be subject to their satisfying APA criteria based on PBS condition as laid down by the EGC in this rule. That is otherwise subject to screening. This is like a promotion under CS.
Just API scores.
Lordship. Now, my lord, I'll take to 2.0. The pay of the incumbent post of lecturer shall be redesignated as assistant professor and shall be fixed at the, this is not relevant for us. 2.1 is relevant, my lord, the second stage of movement. Assistant professor with completed service of 5 years at the AGP of rupees 7,000 shall be eligible subject to other API requirements laid down by this UGC regulation to move up to the AGP of rupees 8,000. So those who have completed, my lord, 5 years with the AGP of 7,000, they would move to the next highest stage, that is 8,000. So my movement from, this can be called otherwise movement from stage 1 to stage 2, stage 2 to stage 3. So my lord, I will not go too much because these are, I have annexed the documents. These are all admitted, I have annexed the orders. We have been given that movement from 1 to 2 to 3. Now my lord will, kindly I will take my lord again to page my lord 7922.
Beginning.
7922.
31/12/2008.
Lordship. Lordship will kindly come to 7923. Same thing, my lord. I will not repeat how the movement will be from 6,000 to 7,000, 7,000. Scheme also say the same thing.
Yes, 7923.
7923. Same thing, my lord. I will not repeat.
2A.
Revise. Yes, A, my lord. Assistant professor. This movement from 7,000 to 6,000. Same thing. Ditto the same thing. Now I'll take my lord to page 7932. This is important, my lord. My rights are based on these conditions. Clause 8, 7932. Lordship has got it. 8. Other terms and conditions.
Clause 8.
Other terms and conditions, increments. My lord, 1, 2, 3, my lord. This annual increment, advance increment, my lord, I am not concerned. I am concerned with clause 3.
Yes.
The number of additional increments on placement at each higher stage of AGP shall be as per the existing scheme of increment on promotion from lower pay scale to higher pay scale. However, in view of the considerable rise in effective pay between the two pay bands, there shall be no additional increment or movement from pay band of rupees 15,600 to 39,100 to the pay band of rupees 37,400 to 67,000. Now this is the pay band. They are saying they have carved out an exception. They say normally any movement from one stage to other side, there would be an increment. Now how many increments, I'll come to it later, would be increments, but they say no increments from movement from this pay band, 15,600 to 39,100 to 37,000. That means from assistant professor to associate professor. Now these are the pay scale of assistant professor and associate professor. When a promotion is made,
come again, Mr. Sen. Just now I couldn't get the last part you said.
Last part.
Yes.
Now what it is saying clause 3 is saying, my lord, there would be additional increments. They have not defined how many additional increments. There would be additional increments.
The number of additional increments on placement each high shall be as per existing scheme.
Existing scheme.
What of promotion? On promotion from lowest scale to highest pay scale.
Lordship.
However, is qualifying in view of the considerable raise in effective pay to the two pay bands, there shall be no additional increment or movement pay band. So I don't understand this.
I am making a Lordship understand. No, it is saying, my lord, there would be additional. Now, what would be the additional increments for movement from one stage of AGP to another stage of AGP? They have clearly mentioned from one stage of AGP to other stage of AGP. Now, in our case, my lord, initially our AGP was 6,000. Then we have moved to the second stage,
stage 1,
7,000,
stage 3.
then 8,000. So our movement was there from stage 1 to 2, 2 to 3, your lordship. Now here exactly they are saying there would be additional increments. Additional increments for movement from one stage to other stage of AGP. However, they said, my lord, in case of movement from these two particular bands, lordship, my lord, that 15,600 to 39,100, that is the pay scale of, this is not movement from one stage to another. This is the pay scale of assistant professor. This is the pay scale. Now, if an assistant professor is promoted to the next higher post of associate professor, the pay band of associate professor is 37,400 to 67,000. So they are saying in case of promotion, otherwise they are saying from the post of assistant professor to associate professor, because of the rise, so considerable rise and enhancement of the revised pay scale, etc., the said promotion will not carry any additional increment from promotion to assistant professor to associate professor. But otherwise, my lord, movement from one stage of AGP to another stage of AGP, my lord, it should be,
as per the prevailing increment.
As per the prevailing increment for normal promotion.
Okay.
Prevailing. So that I'll come, my lord, what it should be. Now, my lord, all issues relating, my lord, lordship will come next to page 7933. Fixation formula. Pay fixation formula, next page on the top.
Yes, B.
My lord, B. Pay fixation formula recommended by 6th Central Pay Commission as accepted by central government shall be adopted for teacher equivalent position in the library. So, my lord, normally the increments are fixed, my lord. I mean, increments are awarded, my lord, while fixing the pay scales, right? My lord, now it is categorically saying how it is to be fixed. It should be fixed as per the central government decision, my lord. I'll come to it. Central government decision and rules made in this regard. What should be the increments?
The pay fixing formula, recommended CPC,
yes,
as accepted by the central government, shall be adopted for teachers equivalent position in the library and
education sets.
But only for library and
no, shall be adopted for teachers and equivalent positions. So teacher also covered by it, your lordship. It has to be by this.
It has to be, yes.
It has to be by this. Now, my lord, this is in nutshell, my lord, what it is contemplated in this regulation. Now, my lord, state government, I will come to the decision taken by the state government. Lordship will kindly take up my writ petition now. 38, page 38, my lord, the government of Meghalaya's decision. My lord, I have annexed the type copy, your lordship. 38 is the Xerox copy, 42 is the type copy, more legible.
Page 41.
Page 42, my lord.
42.
Lordship.
1 second.
Lordship. This is dated, my lord, 23rd March 2010 from the Director Higher and Technical Education. Now,
Annexure number?
This is annexure, my lord. Annexure 2. Lordship. The subject is revision of UGC scales of pay to all eligible teachers of government colleges and deficit colleges. We are from deficit college, so they cover, my lord, deficit colleges in the state of Meghalaya. The undersigned is directed to say that the state government also ordered the adoption of implementation of UGC norms as per Government of India letter dated, my lord, number
The
dated
7922 page. 31/2018.
Same scheme, my lord, which became the part of the, which is, my lord, treated as appendix to the regulation framed by the UGC. So this became a regulation, in fact. It relating to the revision of pay scales, minimum qualification for appointment of teacher in colleges, and other mention at paragraph such and such of the aforesaid letter circular for the maintenance of standard of education in the state of Meghalaya. The UGC scale of pay and DA at central government rates, Lordship will take note more, DA at central government rates shall be applicable to all eligible teachers of government colleges of Meghalaya on submission of option, and the age of superannuation shall be applicable to the state government's employee. Pay and DA of college teacher covered by the scheme shall be fixed in the revised UGC pay scale with effect from 1/1/2006. Next page, my lord. The payment of arrears would be made as and when the resources of the states are available through separate notification. The above instruction shall be extended to the eligible teachers of deficit colleges in the state of Meghalaya, and status quo would be maintained in respect of the age of superannuation of 60 years. The state government has decided in its discretion to fix the pay of the above mentioned categories of employees in the revised pay structure with corresponding academic grade pay with effect from 1st day of January 2006. The authenticated fitment table such and such as forwarded by the Ministry of Human Resources Development, Government of India UGC dated are adopted for the purpose. The Government of India MHRD has offered to render financial assistance to the extent of 80% of additional expenditure involved in the implementation of the revision, subject to the following condition. The central assistance to the account will be available from the period January 1, 2006 to March 31, 2010. The state government will take over the entire financial liability for maintaining the revised pay structure with effect from April 1, 2010. The central assistance will be restricted to revision of pay scale in respect of only those posts which were in existence and had been filled up as on January such and such. Now, my lord general, this is important, your lordship. The pay of teachers of government of deficit colleges shall be fixed according to their designation in two pay bands of rupees 15,600 to 39,100 and rupees 37,400 to rupees 67,000 with appropriate academic grade pay. Each pay band shall have different stages of academic grade pay which will ensure the teacher and other equivalent cadres covered under the scheme, subject to other condition of eligibility being satisfied, have multiple opportunities for upward movement during their career. January 2006 or from such subsequent date as is considered most beneficial to her, she has been alive. Now, my lordship can skip the next few pages, but these are not relevant. Instead, lordship will come to page 45, that is regarding increment. Page 45, my lord, in the bottom. Rate of increment in the revised pay structure. Each annual increment shall be equivalent to 3%.
One second, we're reading from.
My lord, at page 45 bottom.
45 bottom or
bottom,
note?
my lord, 6.
Or 6.
6.
Okay. Yes.
Lordship. Each annual increment shall be equivalent to 3% of the sum total of pay in the relevant pay band and the AGP as applicable for the stage in the relevant pay band.
Each annual increment shall be equal to 3% of.
But this is regarding annual increment. Now, my lord, each advance increment shall, my lord, I am not concerned with that. Lordship can skip. Lordship will kindly come to 3 additional increments because I am concerned with additional. 3. The number of additional increments on placement at each higher stage of AGP shall be as per the existing scheme of increment of promotion from lower pay scale to higher pay scale. However, in view of the considerable rise in the effective pay between the two pay bands, there shall be no additional increments on movement from 15,600 to 29,100 to pay band of 37 such and such. The same thing they are repeating, your lordship. In case assistant professor to associate professor, no additional. But from the stages, from one stage to other stage, there will be additional increments. Now lordship will kindly come to 8. Fixation of pay on promotion / placement on account of career advancement scheme benefits on or after 1/1/2006. Movement from one stage to another stage, my lord, this is under CAS. Now here they say ditto the same thing. In case of promotion placement upgradation from one academic grade pay to another in revised pay structure on or after 1/2006, the fixation of pay of an employee will be made in accordance with the UGC notifications. So, my lord, they are saying as part of the UGC notification. Now, UGC notification is the rules they have framed. Now, the scheme of 2008, your lordship, December 2008, this is from the part of the rules. This is considered as Appendix 1, my lord.
Is it the part of the rules or the backbone of the rules?
No, it is a part of the rules. Lordship, I have examined it. This rule contained of, my lord, the initial title, thereafter annexures, thereafter appendix. So, this has been incorporated as one of the appendix, your lordship. So, these become a part of the rules framed by the UGC, my lord. So, my lord, next. Now, my lord, I will take my lots to how the fixation is to be made. My lord, what is the existing central government, my lord, rules on this? Because UGC say as part of the central government, as accepted by the central government, will apply to the teacher also. So, what has been accepted and what rules has been framed by the central government? That is at page, my lord, 54. The relevant part will be at page 56.
This is which document? 29 August.
Annexure 7, my lord. The rules actually starts from page 55, my lord.
This is the.
This is, my lord, Central Civil Service Revised Pay Rule 2008. This is what my enforced, my lord, Central Pay Revision, 6th Central Pay Revision. Now, my lord will kindly come to page 56. Rule 13.
Rule 13.
Rule 13. Fixation of pay on promotion on or after 1/1/2006. In case of promotion from one grade of pay to another, one grade also they are mentioned, to another, in the revised pay structure, the fixation will be done as follows. One increment equal to 3% of the sum of the pay in the pay band and the existing grade pay will be counted and rounded off to the next multiple 10. These will be added to the existing pay in the pay band. The grade pay corresponding to the promotion post will thereafter be granted in addition to this pay in the pay band. In cases where promotion involves changes in the pay band Also, the same methodology will be followed. However, if the pay in the pay band after adding the increment is less than the minimum of the higher pay band to which the promotion is taking place, pay in the pay band will be stepped to such minimum. So, my lord, they have provided the mode of working out how that additional increment on promotion has to be given when the movement is made from one grade to another grade, your lordship. This is which is followed by the central government, and as per the UGC regulation, my lord, this has to be followed, my lord, by the.
Now this is 3% sum of the pay, means basic pay. In the pay band, on the pay band, yes.
On the pay
3%
band.
of pay band,
Yes.
and existing grade pay.
Yes. And the existing grade pay, your lordships. So, my lord, this is how it is to be calculated. Now, my lord, I have cited an example, my lord, to set at rest, my lord, any confusions. Like various states, my lord, they are invoking, my lord, the UGC regulations. For example, I cited an example of state of West Bengal. They have invoked and they have granted in line with this. I have annexed these documents. Of course, the state government very stoutly saying, my lord, why should we follow state of West Bengal? I'm not saying state of West Bengal is binding on it. I'm just to show, my lord, any state government invoking this is bound to follow this, my lord. This is how it is to be worked out. Now, my lord, that state of West Bengal I have annexed to your lordships at page 56.
56, we're looking at 56 now.
So, my lord, sorry. So, page 59, your lordship. Page 59. Relevant page is at page 62.
Page 59.
Page 59, my lord, annexion 9, and the relevant part is page 62, serial number 8. Serial number 8. Fixation of pay on promotion placement on account of CAS benefits on or after 1/1/2000 case. In case of promotion or placement or upgradation from one academic grade pay to another in the revised pay structure on or after 1/1/2006, the fixation of pay of an employee will be made in the following manner. One increment equal to 3% term of sum of the pay in the pay band and the existing academic grade pay will be computed and rounded off to the next multiple of 10. So, this is basically they are the ditto the same thing they are saying. Because all of them are following that central rules, my lord. Even the regulations say, my lord, fixation will be as per the decision of the central government. So, my lord, there is no doubt about it.
So, you say once a scheme is adopted,
had to be. But that decision is there now, my lord. Last, I'm just about to finish my little bit. Then I'll conclude with that Supreme Court judgment. Now, my lord,
Mr. KP, next date.
Annexion 8. No, Annexion 8, my lord. Annexion 8, these were certain clarification made by UGC. UGC said, UGC, my lord, regarding, my lord, how it is to be implemented. Now, there were certain queries. If a state government, my lord, adopt UGC, certain pay revision, revised pay scale of the UGC, my lord, are they supposed to follow all the regulations, I mean, all the conditions laid down by the UGC? So that was one of the common queries made from various stakeholders. So that has been answered, my lord, at page 58. Serial number 6, my lord, will come. Page 58, serial number 6. This is a communication from the UGC. Now 6, my lord, on the left hand side, your lordship, the query, common query. Are the state government empowered not to accede to the regulation under the local circumstances on the condition of bearing entire establishment cost? The UGC regulation are mandatory in nature. This is the answer. And are required to be followed in letter and spirit without deviation therefrom. So, my lord, they cannot, there is no scope for deviating. That's very clear, man.
This settles your case then?
Lordship?
This clarification settles your case?
Plus this, my lord, that Supreme Court decision has also come. So they put at rest everything, your lordship. Put at rest everything.
What will be the financial implication for the state?
I don't think, my lord. But even can they escape?
Because these deficit colleges.
But then
these are deficit colleges, and my lord, there is no funding from any other organization, my lord. It is state funding.
Can't help.
It is state funding.
But they should have known the consequences while adopting it.
No, the notification itself is very clear, my lord.
Okay, we'll hear you tomorrow.
Let me complete. Now the thing is, my lord, so far, lordship, our movement from stage 1 to stage 2 stage 2 to stage 3. These are not disputed, Your Lordship. I have set it up, my Lord, by making a table at my Lord, at page 16 of the writ petition. That comes under paragraph, my Lord, 8. Paragraph 8.
Right.
Page 16, my Lord, the table. Now, writ petitioner number 1, my Lord, assistant professor English. Now, she joined, my Lord, 1/8/2005. Now, date of placement from stage 1 to stage 2. That means from 6,000 to 7,000. Effective date is 1/8/2011, my Lord. Then from stage 2 to stage 3, that is 7,000 to 8,000, she was placed with effect from 1/8/2016. So, all this placement, my Lord, carries increment, which was never walked out. In fact, I'll calm Your Lordship. They have acknowledged. They have made a communication. There is a communication. They said, yes, they have a right to settle it. So I was expecting when I filed this case, they would settle it. Now, my Lord, writ petitioner number 2, my Lord, stage 1 to stage 2 with effect from 16/4/2013, my Lord, stage 1 to stage 2. Now, stage 2 to stage 3 with effect from 16/4/2018. Now, writ petitioner number 3, my Lord, the stage 1 to stage 2 with effect from 1/6/2014. Stage 2, my Lord, yet to be, I don't know, in the meantime it has been given by Your Lordship, I don't know. So this is the condition. Now, Your Lordship, not only this statement, the relevant order of promotion, my Lord, I have annexed. These will be, Your Lordship, at page, my Lord, starting from 49. in 49, my lord. Starting from 49, Annexure 3.
Yes.
See, my lord, writ petitioner number 1 at serial number 2, English. Date of joining, my lord, first placement, my lord, from stage 1 to stage 2, 1/8/2011. Even they have not disputed in their petition. Now, my lord, next page your lordship will come.
You're in Shillong College?
I'm in Shillong College. And that also, yes, I'm in Shillong College. Now, my lord, lordship. Lordship will come, my lord, to the next page. The same writ petitioner number 1. Now, her promotion, my lord, from stage 2 to stage 3. That has been effected from at serial number 7. 1/8/2016.
Yes.
Stage 2 to stage 3.
Yes.
My lord. So that covers writ petitioner number 1. Now, my lord, we'll come to page 52, Annexure 5. Now, my lord, writ petitioner number 2 at serial number 1.
Yes.
He was given promotion, my lord, from stage 1 to stage 2 with effect from 16/4/2013. Now will the lordship come to the next page, page 53. Serial number 2, my lord, the same writ petitioner number 2. Now, by this order, he has been given promotion from stage 2 to stage 3 with effect from 16/4/2018. So that, my lord, whatever my contention, my lord, supported by all this document, because he made a statement, I have not annexed documents. All the relevant documents has been annexed. Now, your lordship, now I'll take, my lordship, the communication made by the joint secretary on my representation. Several representations were filed. We have been given movement from stage 1 to stage 2. All these things were done. But that increments, they never settled. So ultimately, those representation was answered by, my lord, at page, my lord, 85, Annexure 12. Page 85, my lord. It's not a long one, but I'll just read it. They have referred to the relevant rules and all. Now, my lord, this is from Joint Director, Higher Technical Education to the Joint Secretary, Government of Meghalaya, Education Department. Pay anomalies arising out of fixation of teachers during UGC scale of pay. With reference to the subject mentioned above, I am to forward herewith letters as received from the Principal Synod College, Shillong, including representation of such and such assistant professor, Synod College, Shillong, principal, Shillong College, Shillong, enclosing representation from Srimati such and such assistant professor in English, Shillong, along with all enclosure wherein they have pointed out the anomalies for pay fixation on being promoted from one grade pay to another grade pay that has arisen out of non-implementation or promotional increments as envisaged in UGC Regulation 2010 and UGC Regulation, that is wrong, 2018, and CCS Central Civil Service Revision of Pay Rule 2008. Insofar as UGC Regulation 2010 is concerned, the following clauses clearly clarify the pay fixation formula on promotion from one grade to another grade pay, except that from pay band 3 to pay band 4. Clause 8b states that pay fixation formula recommended by 6th Central Pay Commission as accepted by the central government shall be adopted for teachers and equivalent position in library and physical educations. B. Clause 8a(3) states that number of additional increments on placement at each higher stage of AGP shall be as per the existing scheme of increment on promotion from lower pay scale to higher pay scale. However, in view of the considerable rise in the effective pay between the two pay bands, there shall be no additional increments in the movement from one pay band of rupees 15,000 such and such to pay band of rupees 37,400 such and such. C. Clause of UGC regulation mentioned at A is inextricably linked to clause 13(1) of CCS RPA rules, copy and close. Accordingly, while fixing the pay on promotion to higher pay band, an additional increment of 3% of the pay in existing pay band is added to the existing pay in the pay band. The AGP corresponding to the promotional post will then be granted in addition to his pay in the higher payment. Insofar as UGC Regulation 2018 is concerned, the following clause clarify the pay fixation formula on promotion from one level to another level. Now, clause 19.2 states that promotion, when an individual gets promotion, his new pay band on promotion would be fixed in pay matrix as follows. The promotion, on promotion, the teacher's or equivalent position would be given notional increment in his her existing academic level pay by moving him her to the next higher cell at that level, and the pay shown in this cell would now be located in the new academic level corresponding to the post to which he or she has been promoted. If a cell identical with that pay is available in the new level, that shall be the new pay. Otherwise, the next higher cell in that level shall be the new pay of the teacher or the equivalent position. If the pay arrived at in this manner is less than the first cell than in the new level, then the pay shall be fixed at the first cell of the new level. Copy and close. The view of this directorate is that teachers are well within their rights to point out the anomaly as described above, since while extending the UGC pay scale, it seems that pay fixation formula also needs to be followed in totality. In view of the above, the government requested to kindly extend the promotional increment while promoting the teacher of both government colleges as well as deficit college, aided colleges from one stage to another stage.
So what happened after this?
No, they have not, my lord. I was well filing these, nothing was happening. I was under expectation that it will be shorted or once I file it. Now I will come to
now for 2020, now this proposal is already accepted that they are entitled to their promotional increment.
And what the Supreme Court after that, my lord, there is no iota of doubt.
No, but then the only thing that stops them must be
I'll
financial.
I'll come. Now, my lord,
only
the government has filed an affidavit. Interestingly, Lordship, while I filed this case, I was very conscious about it. There are two teachers from Synod College, one from Shillong College. So, my lord, that came to my mind. Shall I make a single petition or shall I make separate petition? Well, I looked into Order 1, Rule 1, my lord. Order 1, Rule 1, CPC, my lord. We will be guided by that. No, Order 1, Rule 1 very clearly, categorically say, all those parties, they can join together in a single proceeding if there is a common question of law. Here, my lord, one common question of law, whether the movement from stage 1 to stage 2 carry an increment, if that increment is binding on the state government or not. Suppose, my lord, because they have taken up this ground, I should have filed separate petition. Now, suppose your lordship, there is a common question of law. Suppose I had filed, my lord, 2 or 3 petitions.
That would
lordship would have clubbed.
We have clubbed together, but then this individual cause of action. But the thing is that we'll have to examine that also. They might have a ground.
No, so that they have taken up. So my humble submission, my lord, that cannot be. I am not burdening your lordship with combining, my lord, many cause of action. There is a single cause of action. All are assistant teachers. Their movement here under CAS. Now, my lord, even the communication from the government, my lord, to all the teachers by a single communication, common order. So, my lord, now I will come to their affidavit. Now, lordship is seeing concerned. Lordship is concerned with the financial implication. No way they say we have financial.
I'm saying that why, if in principle they have said that you promotional increment, you're entitled to it. That's what they said. In principle, they've said that. They've given that letter 2020 August, right?
And it is there in that decision also by which they have adopted.
So why have they not done it?
They are, I am unable to understand. They should have done it. Now, in their affidavit, now when your lordship has said financial implication, my learned friend immediately stood up, yes, financial implications and all. Not a whisper in the affidavit that we have financial con. They cannot say it also. It is binding on. They cannot say. It's not there. They are saying whatever is entitled, we have given to them. Nothing more they are entitled. And second thing, they are saying that separate petition.
No, they're not. See, one thing, they're not contesting your eligibility.
They cannot contest.
They're not contesting that. You're not contesting that, correct? No. Now, what is the hurdle?
What we have stated.
Well, are you saying that they're not entitled for some reason?
No, in our affidavit, we have primarily stated that whatever they are entitled, it's already been given to them.
Oh, that point. Okay.
Yes.
Even promotional increment also has been given.
It's been given to them.
No, where is the promotion?
That's what he said. That's what,
That is
that's
what
the
the
submission.
affidavit says.
No. I think we have to continue tomorrow, Mr. Sen.
Tomorrow?
Lord,
let it be tomorrow, my lord. Then the continuity remains. Otherwise, my lord, now things goes out of mind.
Can it be on Friday, my lord?
My lord, Friday, your lordship should not be.
Or Thursday? Friday?
Lordship can be, my lord, and Wednesday. Tomorrow is the best, my lord, because
the thing is that, yes, you see, this court won't be here for quite a long time.
From when, my lord?
That's the third week of May. Huh?
From third week, lordship.
But can it be taken up on Thursday, my lord?
See, the only thing is that, see, because there's some other works I have to do, that's why I want to.
No, that's all right.
Yeah, that's the thing, actually, if you drive 1:15, I've got to come back at 2, but then some urgency. Only thing is, I don't want to, like Mr. Sen, I don't want to, have half helping, the next helping after 3-4 days, you forget what you ate earlier, no? It's like that. One meal should finish, no? That's
exactly. That's why I'm saying, lordship, tomorrow is better always, your lordship.
Once Wednesday,
then you can have a continuity.
Lord, Wednesday, tomorrow and day after, I have some
difficulty.
Yes, sir.
Thursday.
Thursday, I'm okay, man.
Thursday, yes, sir.
Things remain
any conclusive. Mr. Sen's really finished. Only thing is that is
only the decision
prayer that find that that whatever is all implemented this all. So what in effect you're looking for a time frame implementation.
The state in their affidavit has also stated, my lord, that certain anomalies have come and other steps are being taken for correction of the same.
Keep this for time being.
Yes, lordship can retain. Well, I have this.
So that is also stated in our affidavit.
Hearing inconclusive will resume on Thursday, the 8th. Oh, no, sorry. Thursday the 11th.
Lordship will come as a part matter. Otherwise, will go down into bottom. We don't know. There will be supplementary release.
Will come in supplementary release.
Hearing will come supplementary. A part matter.
You won't go to any other bench, Mr. Sen. No. It's like in Ghati where suddenly your case will be listed, kicked out to court number 9 or 10 or something like that. No. Yes. Yes. What happened?
No, Your Lordship, just to mention the earlier matter which
yes.
has been withdrawn to be listed tomorrow if it's possible.
Yeah, listed tomorrow. You file it, yes.
Okay. Much.
They should, how you draft writ petition is very important. You know this one thing about I've noticed with regard even the first case. I'm very sorry for that little girl who was submitting. I mean, that's not. You see, you have to come stand for the court. You know on what basis studying also. Some senior lawyers send them go because it looks like a hopeless case. See, like exposing your juniors also. Two things should be, like on a case which is, there's some grounds and at least poor thing, you can't put them in difficulty like that. Very unfortunate. Yes.
Vấn đề